Whenever I will sit singly, yes.
My lord, an appeal had been filed, my lord, on the 15th of May. My lord, we could not get it listed. That's why, my lord, I was mentioning the matter, my lord.
Why has it not been listed, Mr. Shah? Dakho, give the number.
Let it appear in the list, and as per your lordship's convenience, my lord, the matter may be called.
Dakho, original side.
Yes, ma'am.
Dekhe na.
Great.
May I, my lords, kindly to mention one matter. The appeal is listed tomorrow for hearing. I'm praying for filing an urgent application, interim application under Order 41 Rule 27 for relying on some additional documents and also seeking stay of a particular notice in which the AGM of the Calcutta Swimming Club has been called, where the last date for filing of the nomination is 13th of June. If your lordship doesn't permit it, then hears it out, then I'll...
What stops you from filing it?
No, because I'm in suspended. That is the subject matter in the appeal.
What stops you from filing?
Oh, no. The 24 hours, your lordship, it's to be listed.
File it.
The leave of Justice Banerjee, I am mentioning one matter, few matters for correction.
Before
Yes.
Justice Chattopadhyay?
If the slip, whenever I'll sit singly, it will be taken.
May I have leave of my lord Justice Banerjee to mention matter before my lord Chattopadhyay. My lord has fixed this matter today. The two contempt matters, my lord. I'm just praying them whenever my lord sits singly, please let this matter be taken up.
Yes.
Original side matters, my lord. Grateful, lord.
Any other audience side mentioning? Appellate side mentioning? Appellate side, Commercial Division, item number 1.
Item number 1, I appeal on behalf of the appellant plaintiff, my lord. On the last occasion, my lord directed to serve a notice upon the learned senior advocate, Mr. Oniban Ray, my lord. As per my lord's direction, I have served, my lord. My lord. My lord, this is the service, my lord. My lord, kindly excuse me, it is not in form of affidavit, my lord, but I have served, my lord. There is a receipt annexed to the letter, my lord.
Anybody here who is on the state panel? Any learned advocate? You are there on the state panel? It will go ex parte otherwise against the state. Last 3 occasions, nobody appeared for the state. Please take responsibility and look into it. We don't want to proceed ex parte. We'll keep it day after tomorrow.
Very well. Very well.
Accept service from your learned friend if you are instructed to appear, or whoever appears. Give another copy.
I'll find out who's there in the matter.
Mr. Nilotpal Chatterjee.
Nilotpal Chatterjee.
Yes.
বলেছি। But Mr. Nilotpal Chatterjee, I am in.
Oh, yes.
Served him as well, my lord.
Yes, once Mr. Anirban Ray, Jayanto Samanto, Nilotpal Chatterjee, Parikshit Goswami.
May I say something, my lord? Instead of, my lord, keeps it, my lord, sometime, my lord, instead of day after tomorrow, my lord, I'll inform Nilotpal. I'll inform, my lord, Mr. Chatterjee as well as, my lord, who else is there?
Please inform, and it will be day after tomorrow. If the state is so nonchalant and indifferent, then we will pass ex parte orders. We are giving sufficient opportunity. Just not today and tomorrow করে রেখে দাও না রেকর্ড করো
অনির্বাণ স্যার আছেন তোমার নাম্বারটা দাও ক্লার্ককে দিয়ে পাঠিয়েছি
Further to our direction, fresh notice dated May 8, 2025 was served on the office of learned government leader, as also on Mr. Nilotpal Chatterjee, learned advocate representing the respondents. Respondent karo. Stop. However, nobody appears for the respondent. Stop. Paragraph. List this matter once again on Porshudine date thou. Stop. On that date, if nobody represents the respondent, this matter is likely to be proceeded with ex parte. Paragraph. Learned advocate for the appellant is requested to communicate this order two learned advocates for the respondent.
My lord, I shall deeply
You also informally tell them.
deeply day after tomorrow থাকবে দাদা
Matter number 2. No, this is my appeal. Now, there was a direction to serve upon the respondent. Now, the service is complete. ফাইলগুলোকে ওইদিকে রাখবো না এখানেই রাখবো এদিকে রাখবো
Yes.
Yes, if I may proceed. My lord, in a nutshell, my lord, the pro forma respondent, my lord, whom I have pleaded, the government entity, my lord, had floated a tender. But in that tender, my lord, the respondent number 2 was the principal contractor. The original respondent was the principal contractor. My lord, subcontract was given to us. My lord, the nature of work is, my lord, your lordship will find military engineering works, my lord, which was to be done in the site of the pro forma respondent, my lord, who is a non-signatory. Now, my lord, my contention in the section 9 application was very limited, my lord. If your lordship kindly looks into the prayers, my lord, kindly comes to page 30 onwards. My lord, specifically 31, my lord, I had moved the
Internal page
my lord, 30 internal page 17, my lord.
of the order, impugned order.
No, my lord, I am placing, my lord, from the paper book, if your lordship sees, my lord, page 31 and internal page 17 of the section 9 application. Now, this is an application under section 37.
No, no, we have understood that. Let us see what the order is.
My lord, kindly have a look into the order. Lord, she will kindly take up 511, my lord, starts. And my lord,
Please
the
just sit down. You wanted security for your claim and you wanted to remove your machinery
yes,
from the
my
site.
lord, court proceeded on the point of jurisdiction. Court did not enter into the merits, my lord. The court thought that it does not have jurisdiction on the ground of the seat of arbitration. But that perhaps is not the correct position of law, because, my lord, section 9 will be guided by section 21E of the act and not on the jurisdictional seat. Now, that is the, my lord, error on the part of the court, my lord.
Very well. Yes, this is a point of law.
Yes.
One more opportunity. Do you know who represented the?
No, nobody represents. That is the predicament, my lord. This
It was an
original
ex parte.
respondent, my lord, is hiding and running away.
This was an ex parte order before the learned.
Yes, because, my lord, the pro forma respondent appeared. The original respondent did not appear.
Pro forma may have not much to say.
No, they are saying that, my lord, until and unless the respondent, original respondent is represented, there is no privity of contract between us. Because today, my lord, what we are suffering is that our assets, my lord, your lordship will find, I have described, that 24 assets which are lying with them. My business is absolutely stalled.
So even if the pro forma respondent is before us, the site is in their control.
Yes.
So
All I was seeking was only an inventory to know whether my assets are there or not. Nothing more, nothing less.
yes.
But that is only, my lord, I am only praying before your lordship. I am not even seeking custody of the assets. Just to ascertain, my lord, whether the assets are there or not. No, they are valuable assets more than, my lord, 10 crore rupees. The court rejected the prayer since, my lord, court thought it does not have the jurisdiction.
Where is the arbitration clause?
No, the arbitration clause, your lordship will find, but the subcontract starts at page 450.
Stay application though?
Kindly have a look at, my lord, at page 455.
এরকম কি করে হ্যান্ডেল করবে?
And my lord, 456.
So you see the seat of arbitration is where?
No, with deepest of respect, my lord, seat of arbitration has got nothing to do with the section 9 application, because section 9 application, my lord, only section 2(1)(e), my lord, principal court of original civil jurisdiction, which is the commercial, which is the Asansol commercial court. Lord, the court proceeded that in view of the judgments of BGS, SGS, Soma, that now jurisdictional seat would only operate. That is only in
Your
respect of
contract
30.
has been terminated.
No.
Contract had not.
But he just evaded and he left. My lord, I have payments of more than 5 crores due.
হ্যাঁ, performer to site is in control of issue. This appeal is directed against a judgment and order dated July 20, 2024, passed by the learned judge, commercial court at Asansol, whereby the appellant's application under Section 9 of the Arbitration and Conciliation Act, 1996, being miscellaneous arbitration bracketed commercial :01/2024, was dismissed, holding that the learned court had no jurisdiction to entertain the application. Paragraph. The appellant says that it is, he na she,
Company.
Neeraj, he is a subcontractor against the respondent number 1, which was awarded a contract by the pro forma respondent. What kind of contract was it?
It's a construction of school
A
buildings.
construction contract. Construction contract.
Infrastructure contract.
By infrastructure contract, by the pro forma respondent. Stop. The appellant did substantial work, and as of now, approximately rupees 5.50 crore is due to him from the respondent number 1. Stop. The equipment and machinery of the appellant are lying at the site of work. Stop. The respondent number 1 has suddenly vanished from the scene, leaving the appellant in the lurch. Stop. All that the appellant presently asks for is that an inventory of its equipment lying at the site of work be prepared. by a special officer to be appointed by this court. Paragraph. On the point of jurisdiction of the learned trial court to entertain the application, we find that the appellant has an arguable case, a prima facie arguable case. Stop. The learned trial court may not have been entirely correct. May not have been correct in holding that since the seat of arbitration is in Ranchi, as per the arbitration clause in the contract, the Asansol court had no jurisdiction in the matter. So, however, we propose to decide the issue of jurisdiction at the time of final hearing. Stop. This is only a prima facie observation. Paragraph. We find from the affidavit of service filed in court today that the respondents have been served. Stop. However, nobody represents them. Stop. We are told that even before the learned trial court, the respondents did not appear.
The respondent number one, the main
Yes.
respondent, the performer appeared.
The private respondents did not appear. Stop. Paragraph. Considering the facts and circumstances of the case and the averments made in the stay petition, we are inclined to allow the appellant's prayer for preparation of inventory of his equipment and machinery lying at the site of work. So, for this purpose, we appoint Mr. Blank as the special officer to, where is this site?
In Purva Bardhaman.
Purva Bardhaman.
Purva Bardhaman.
To prepare such inventory. Stop. The special officer will be entitled to an initial remuneration of blank to be paid by the appellant at the first instance. Stop. The appellant shall make all arrangements for visit of the special officer to the site of work and extend full cooperation to the special officer so that he can carry out this order. Stop. Prior to making inventory, the special officer shall serve notice on the private respondents as well as the pro forma respondent. And if the respondents / pro forma respondent express their desire to be present at the site of work at the time of preparation of inventory, the special officer shall permit them to do so. Stop. However, they shall not interfere with the special officer's work in any manner. Stop.
Extend cooperation.
If the special officer apprehends any kind of resistance or violence, he / she will be at liberty to approach the jurisdictional police station for police help. Stop. If so approached, the officer in charge of the jurisdictional police station shall extend all cooperation and grant necessary protection to the special officer for the purpose of implementation of this order. Stop. The special officer shall only take symbolic possession of the equipment and machinery lying at the site which belong to the appellant and which will be identified by the appellant or his representative. Stop. That is all for the time being.
Only thing that I was apprehending, since it's a military compound, my lord, perhaps along with the police, my lord, appropriate authorities belonging to the military should also be,
Oh, I
brought
see.
into the
Like
fold.
military compound.
Yes, it's a military compound.
What is it?
It's not military totally, my lord. It's their construction, their dwelling places being constructed. So it's not.
তাহলে ওই যেখানে বলেছি so approach the officer in charge of the judicial police station বলেছি ওটা আমি, as also the concerned military authorities,
That is requirement.
as also the,
They would not let me in.
ঠিক আছে, paragraph, let this matter be listed again, আজ কত তারিখ? 10, on after 2 weeks or what?
3 weeks, my lord, because
3
it will
weeks.
take some time to approach the receiver. Receiver has to go.
After 3 weeks মানে কত?
যাবে inventory নেবে permission নেবে
1st July, July 1, when the special officer shall file his report before us. Paragraph, since the respondents oblique pro forma respondent are not represented today, comma, learned advocate for the appellant shall communicate this order to them. Mr. Sen, something has to be. Dekhi now. If a stay petition is like this, how do we handle it?
Now
400,
now they've made it into two separate volumes.
500 pages.
But in the original side now, my lord, we have
I know there's an administrative direction on the original side, maximum of 150 page perhaps.
that is not there.
Something of that kind has to be done. We'll sprain our wrists, you know.
Of course, but your lordship will give a the practice direction.
We will talk to the Chief Justice and then we will.
Should be the same for all the sites, my lord. Otherwise, it's really difficult.
Very difficult.
And my lord, papers may be torn. That's the worst part.
Yes.
Your lordship has fixed the remuneration of this session.
Tell us how much. We have kept it blank.
I leave it to your lordship. Lord. Not much.
We don't know the kind of work he'll have to do.
My lord,
the
because
magnitude.
the lordship will find in page 24, my lord, we have disclosed the assets. So my lord, similar list will be forwarded to him with the invoices that these assets belong to us.
It will also depend on whom we appoint.
Yes.
We tell you it will be between 20 and 25. And your client will make all arrangements.
He shall. Not somebody very junior, otherwise, my lord, he might not have the
We have
understanding.
understood. We have understood. Yes.
Because it's a military area, my lord, he might not understand the protocols are there, my lord.
Yes. Mr. Ghosh? Would you be willing? No, don't hesitate. If you don't want to, don't go.
I cannot say anything. The wish your lordship share.
No, if you don't have any other problem, then please go. Only one day will suffice.
Use inventory, my lord.
They'll make all arrangements. Purbo Bardhaman is not a bad place.
I think it will be in Panagarh.
Mr. Chittapriya Ghosh. Huh? একবার বলে দাও, who is present in court.
But our persons will assist him, my lord.
Of course. 25,000.
Grateful.
Item 3.
My lord, I am appearing on behalf of the appellant. My lord, I am seeking for the adjournment. Because of that, Section 9 applications is pending and the talks of settlement is going on between the parties. But the thing is that whatever the amount they have claimed from us, the rest
How long do you want?
the amount has been
How
3
long?
weeks.
Learned advocate for the appellant says that Talks of settlement are in progress between the parties. Stop. On her request, comma, let this matter stand adjourned and be listed again on July 1, comma, 2025.
Item 4,
I appear for the respondent.
And for the petitioner, my lord.
Yes.
Yes. My lord, on the last occasion I had submitted, there is a partnership firm for a brickfield operation, my lord. The partnership has been entered into.
I'll raise the point of maintainability.
From 2020, my lord.
Why is it not maintainable, Mr. Banerjee?
My lord, kindly seize, my lord, the order which they had suppressed before the, my lord, trial court for obtaining a Section 9 application. Order, my lord. Kindly seize the Section 11 order, which is now they have annexed with the, my lord, appeal cause papers at page 215.
Arbitrator has been appointed?
Yes, arbitrator has given, my lord, a date.
Submitted on the last occasion.
Has given a date which is this Friday or Monday, my lord. And my lord,
16th.
Section 9 has been filed post appointment. They tried to obtain an order where the trial court has rightly refused it, saying, my lord, that it should be before the arbitrator.
Ms. Bose, go before the arbitrator. Why are you fighting here?
My lord, on the last occasion, my lord, firstly, I had not suppressed, my lord. On the last occasion, I had also
No,
submitted.
we will say nothing on suppression. We will say nothing on suppression. We'll just say, since the arbitral tribunal is now available, we are not inclined to exercise our discretion. You'll be at liberty to make your prayer before the tribunal.
My lord, we shall submit before the arbitrator, my lord, but
Yes.
this is going on day to day. We need some entry into the business, my lord. We are being prevented from entering the business.
No,
Kindly
Bose.
pass that order, my lord.
No, Bose, Mr. Bose, Ms. Bose, we are not inclined. We are granting you, file your application before the arbitrator today itself. Who stops you? Nobody stops you. Which is the impugned order?
My lord,
But the
the
impugned
procedure
order
will
is-
start from that point onwards, my lord. That will take
My
some
lord, in the
time. And this is
memorandum lordship
before the
sees the
onset of
interim order
monsoon,
is-
my lord, this is the peak season.
No, you
for
pray for ad
manufacture of-
interim order if you want to. You can ask for any relief that you can ask for before the court. 11th of February.
11th of April. 10th of April, appointment by this honorable court. 11th of April, they go there, my lord. Without showing this order, they tried to
My
obtain a
lord, we
Section
filed
9
the
ex parte.
application prior to that, my lord.
And 10th, my lord, a contested Section 11 was appointed. The arbitrator was appointed.
And we have explained, my lord, in why we had proceeded ex parte, my lord. We have the pleading, my lord. And my lord, they have committed fraud, my lord. They have converted the partnership business into a proprietorship business, my lord. I
Not
have
on
the
merits,
paper,
my lord. I'm
my
not
lord.
saying anything on merits, my lord.
And
The Section 9 is pending.
Yes.
yes, my lord.
Pending.
Against that we have come, my lord.
But post Section 11 order being passed on contest.
Last occasion, my lord,
We
I had
understand.
submitted everything,
But
my lord.
is it on that ground that the interim order was declined?
The interim order was declined because, my lord, they tried to move
my
it
lord,
ex parte
we
without even informing the court that, my lord, on 10th itself the
My lord,
appointment
we
has been
wanted
done.
to appoint a receiver, my
This
lord.
order does not reflect that they suppressed anything.
Because, my lord, the court didn't know even.
Correct. So I'm trying to say is that the court declined on merit.
Yes, yes.
Ex parte ad interim
Yes.
order.
My lord.
That's recorded in the order itself, my lord. Very categorically.
Ms. Bose, we are granting you all kinds of liberty, but we are not inclined. Lekho, this appeal, by consent of parties, you don't believe, huh? Taken up for hearing together. This appeal is directed against an order dated April 11, 2025, whereby the learned judge, commercial court at Alipur, refused to pass an ad interim order of an ex parte ad interim order of injunction on the appellant's application under Section 9 of the Arbitration and Conciliation Act, 1996, being Miss Arbitration bracket com bracket close 20 of 2025. Stop. Paragraph. The appellant says that although he is a partner of the concerned firm, comma,
And a major shareholder, my lord. Major shareholder, my lord.
holding majority share, comma, he has been ousted from the business of the firm. Stop. He is not allowed to participate in the business or enter the firm's office. Stop. He prays for.
And at page 208, my lord, it's there that they have converted into a proprietorship firm. When they're paying GST, they have.
He prays for an immediate order directing the other partners of the firm to permit him to participate in the affairs of the firm. Paragraph. We find from the order impugned that the learned trial court, comma, after considering the submission of the appellant oblique petitioner, comma, recorded its finding that there was the finding that no case for ex parte ad interim order of injunction had been made out. Stop. It is a reasoned order. Stop. We do not find any perversity or material irregularity in the order. Stop. The learned trial court, paragraph correct. Learned trial court directed notice to be served on the respondents oblique opposite parties. Stop. The application under Section 9 of the 1996 Act is still pending before the learned trial court. Stop. Paragraph. More importantly, comma, by an order dated April 10, 2025, comma, this court.
Yes, my lord, on contest.
This court, a learned judge of this court, comma, on an application under Section 11 of the 1996 Act, comma, has appointed a tribunal or sole arbitrator.
Sole arbitrator, my lord.
A sole arbitrator for adjudication of the disputes and differences between the parties. Stop. The order dated April 11, 2025, which is sought to be assailed before us, does not reflect that the learned trial court was informed that an arbitral tribunal is already available. Stop. Anyway, we do not go into the question of suppression of material facts or otherwise, as the same may not be necessary immediately. Paragraph. In view of the fact that the Section 9 application is still pending, and additionally, an arbitral tribunal has already been constituted before which the appellant may make his prayer for interim relief, we are not inclined to entertain this appeal, not inclined to pass any order on this appeal, which accordingly stands disposed of along with the connected application. Stop. Nothing in this order will prevent the appellant from renewing his prayer before the learned trial court or approaching the arbitral tribunal for interim relief, in accordance with law. Stop. If so approached, the learned trial court or the arbitral tribunal, as the case may be, shall consider and decide the appellant's prayer strictly in accordance with law, comma, without being influenced by any observation in this order.
Only thing is that, my lordship, my lord, the allegations are denied by us.
Yes,
No
yes, paragraph,
affidavit.
since we have not called for affidavits, comma, the allegations in the stay petition
Yes.
are deemed not to be admitted by the respondents.
Great.
My lord, I appear for the appellants. But I'm led by Mr. Jishnu Shah, Lordship. He's made a request that he wants to address your Lordship. I told that he's on legs. If a very short passover be given, Lordship.
No, Mr. Sharkar, pass over.
But there is some urgency in the matter. So,
We don't know, pass over, you have asked for, we have granted your request. Next, Daku.
As my lord, please.
Item 6.
Yes.
Lord, I appear for the appellants, my lord.
For the respondent.
Your lordship will kindly consider your lordship's last order of 20th May 2025. In fact, my lord, first order, starting from the first order, my lord, 24th April. April, your lordship had granted an unconditional stay and then allowed me time 2 weeks time.
Let us go through the orders, Mr.
Yes.
Gupta.
24th April, my lord.
Yes, demand draft.
The difficulty is not my client has not been able to arrange because there's some GST issues because of which his bank
Mr.
account.
Gupta, then twice we have granted you.
I'm not,
Yes.
I'll leave it up to your lordship. Only thing is what my instructions are, may I just indicate that,
Yes.
Lord? Okay, my client has instructed me, Lord, that if time till Monday is given, Lord, he will arrange it. Otherwise, he'll try and arrange it by Monday. That is my instruction, Lord. Otherwise, I leave it entirely up to your lordship.
Condition, Lord, as per the code of civil procedure, is a precondition for
Correct,
stay.
correct.
Lord, I leave it up to your lordship. I leave it up to your lordship.
Mr. Gupta, we are not disposing of the stay petition then.
Very
We'll keep it on, we are not extending the stay.
Very
By Monday, there'll be no execution. You can take it for granted.
In fact,
Assumption is that there is no execution pending.
No, in fact, your lordship's order was till 23rd of May.
Yeah.
We waited till today, my lord. 2
Yes.
weeks have passed. I know,
Uh,
my lord, my learned friend will not file an execution case till that time.
No, I'm not yet filed. As per my
Read
instruction.
orders dated April 24, 2025, May 8, 2025, and May 20, 2025. Paragraph. Mr. Gupta, learned advocate for the appellant, says that due to some GST,
My lord will not record.
due to some unavoidable circumstance, the appellant has still not been able to arrange for security for the balance decretal amount. Stop. As a last opportunity, he requests for time till সামনে সোমবারের টাইম তারিখ কত 16,
Your
July,
Lord-
June 16.
Your lordship takes it up on Tuesday, so 16th, yes, Monday.
Comma 2025. For securing the balance dictatorial amount. Paragraph. List this matter once again on July 17.
June 7th.
June 17, comma 16, 2025. Stop. However, we do not extend the order of stay.
Lord, may I just pray for one more indulgence? If your lordship has seen, we have deposited 6.5 lakhs. Lord. Now, this is possibly lying in the account, Lord. If
Should be invested.
invested, Lord, so that it.
Why don't we do it all together? If you secure the balance amount also,
Lord,
in 6 days, what difference does it
very-
make? If you bring that demand draft, we'll take it, we'll direct the whoever registrar to invest 6.5 lakhs and the remaining amount together.
Very
Much of
good. Hit up.
Item 7.
I am for the appellant. So my affidavit of service. This is
You are for all the respondents. Allow us to go through the order. Yes.
My lord,
What is
during
the error in the order?
my lord,
Simpliciter money claim, why should the court secure it?
this is a money claim.
Hmm.
My lord, during subsisting of the development first agreement,
Yes.
the landlord entered into the second agreement with the respondent number 5.
Yes.
Not only that, they are revoked the power of registered power of attorney. According to the section 202 of the Contract Act, the revocation of the subsequent registered power of attorney.
Where is your plaint? Where is your plaint?
The plaint is the page 24. Sorry. Start from 19. Start from page 23. Thank you.
Pure money claim, nothing more.
No, Malada, this is that money claim arising out of the illegal termination of the development.
Where have you challenged the termination? In another suit.
Challenge
In another suit.
another suit.
Correct? There you had obtained,
an order of injunction.
then vacated.
Subsequently, that has been vacated during pendency of the said suit. Another suit has been filed by my learned friend, and they also obtained an order of injunction.
Why was the injunction that was granted in your favor earlier, why was it vacated?
Well, during that time, the construction work has been completed. Well, by the respondent number 5. Well, if the construction work has been completed, therefore this suit has been filed after compliance.
Prove your claim, obtain a decree for 1.39 crore along with interest, execute the decree, get your money.
Completely multiplicity of the proceeding has been invited if your lawsuit do not protect my client.
Sir, you have been unable to obtain protective orders before the other courts also. There is this impugned
challenge on the revocation of the power of attorney. Well, if your lordship kindly come to the that place.
All right. No, sorry, sir. There is no error in this order.
But
Well reasoned order.
The prima facie case has not been found out by the learned trial court.
Correct.
No, because during subsisting of the development agreement, entered into the another agreement. During that period, more than 40 lakhs rupees has been spent without protecting that proposition. My learned trial court had not find out any prima facie case. Even according to the section 202 of the Contract Act, but the subsequently revocation of the power of attorney without consent of the developer, that is also illegal. That illegality has not been specifically mentioned in the order sheet. The entire order totally perverse. But my only prayer before your lordship, kindly protect during pendency of the suit. Some protection may be given. Otherwise, we obtain the degree, but that would not be executable, and developer will be go away, and landlord will be taken possession of their own flat and enjoying them. During that period, my 40 lakhs rupees is good.
There is no evidence of your 40 lakhs having been.
Evidence, yes. If your lordship kindly come to my injunction application. My injunction application, there is some challenge and also been
How many challans you want? Your learned friend will produce 48,000 challans tomorrow. Prove your claim, sir. Prove your claim.
But it is fact that the agreement has been executed between the parties. In the 2012, 2014 sanction has been made, and 2017 the power of attorney has been
also
revoked.
finding that you have failed to perform your part of the deal.
Well, that
Your
is the
obligation.
question. Question is
That is tri-
14 to 2017. Well, the construction is going on. I already been invested huge amount of money. Well, that has not been considered by the learned trial court.
Very well, sir. We have heard you now. Allow us to dictate our order.
Well, kindly protect. Some protection may be given.
Not in this case. This appeal is directed against a judgment and order dated March 4, 2025, whereby learned judge, commercial court at Rajarhat, North 24 Parganas, dismissed.
Refused.
Dismiss Corona. Refused to allow the appellants the essay for apostrophe, prayer for temporary injunction under Order 39, Rules 1 and 2, read with Section 151 of the CPC. Stop. The order was passed on contest. Stop. Paragraph. The appellants say that an agreement, a development agreement was entered into by and between the respondent numbers 1 to 4 and the appellants in respect of the concerned property. Stop. The agreement was executed in 2012. Stop. The appellants started work and invested substantial sums of money to the tune of at least rupees 40 lakh. Stop. Suddenly, the respondent numbers 1 to 4, without terminating the agreement with the appellants, entered into a fresh agreement with the respondent numbers 5 and 6 for the same development work. Stop. Subsequently, in 2017, the respondent numbers 1 to 4 cancelled the power of attorney that they had executed in favor of the appellants. Stop. The appellants say that the project has now been completed by the respondent numbers 5 and 6. Stop. There is every possibility of the flats that have been constructed being sold off to third parties. Stop. In that event, even if the appellant succeeds in obtaining a money decree in the suit that the appellants have filed, the same will be a paper decree, as nothing will be left against which such decree would be executable. Stop. Therefore, the appellants pray for an order of injunction restraining the respondents from alienating or dealing with the flats in the newly constructed building. Stop. We have not called upon learned advocate for the respondents to make submission. Paragraph. We have carefully considered the judgment and order impugned in this appeal and also the submission made on behalf of the appellants. Stop. The suit filed by the appellants is purely a money suit. Stop. Apart from praying for a money decree, no other relief has been prayed for. Stop. The learned judge has rightly held that a pure money claim which is at the highest and unsecured debt, ought not to be secured. Stop. Secured in ordinary circumstances. In ordinary circumstances, stop. We also find that no case under Order 38, Rule 5, CPC has been made out. Stop. Paragraph. Furthermore, comma, the learned judge has found, and we also prima facie find that there is no material to support the appellant's case that they have invested approximately rupees 40 lakh in the project. Stop. We also find that the learned judge has found, as a matter of fact, at least prima facie, comma, that the appellants failed to perform their part of the deal, which prompted the respondent numbers 1 to 4 to enter into a fresh agreement with the respondent numbers 5 and 6. Stop. Paragraph. Having considered the submission of the appellants and the judgment and order impugned before us, comma, we are of the view that there is no such infirmity in the order of the learned trial court which warrants our interference. Paragraph. The appeal and the connected application are accordingly dismissed. Paragraph. However, we request the learned trial court to expedite the trial of the suit and take the same to its logical conclusion as soon as the business of the court may permit. It agreed by consent of the parties. Sir.
Get pulled.
Item 9.
सामने कागज नहीं माने टाइम चाहिए.
Yes.
Yes.
But I would be praying for an adjournment for the week, my lord.
For a week.
Yes, my lord. Kindly takes it up any day next week, my lord. I'm led by Mr. Jishnu Chaudhary. Some.
No, no.
Kindly.
He's in Goa.
No, he's here, but he's in some.
Bhuvaneshwar. Yes, Mr. Mitra.
No, not.
Oh,
He's
in Alaska.
No, he's in Calcutta.
He's in
But
Calcutta.
he's not in High Court.
You disappoint us. What is this? 1 week, Mr. Mitro. 1 week they're asking for. On the likhe now. Request made by learned advocate for the appellant, comma, let this matter stand adjourned and be listed again on next Tuesday, the other. Oh, this is that.
Yes. And he.
Your suit for declaration and delivery up and cancellation has been dismissed. Rajarhat.
Mr. Chaudhary is very emotional about this. We won't let anybody argue and he will. So I cannot take any chance.
Very well. Come back. Hey, এটা কোনটা বলি?
আগের judgment. Read থেকে যেটা division.
My lord, and I was the same which was there. Next Tuesday?
Would your lordship fix it? No, it will appear at the top or
At the top of the hearing list, as it is appearing today, being the only hearing matter. Second call, Koro.
Number 5, passover matter.
My lord, I'll just pray that for not today because Mr. Shaha is still
Yes, yes.
in that event, my
Mr.
lord.
Sarkar was telling us there is tremendous urgency in this matter.
Actually, my lord, there is urgency. This relates to a T.
On the request made by, huh?
This matter be kept on Tuesday instead of Thursday, my lord. I have some personal difficulty on Thursday.
They are on caveats, so we have already served. My lord, I'll
Received, I'm for the defendant number 2, 3, 4 there.
Ensure that service is complete.
Yes, my lord, we are carrying the affidavit of service.
Very
We'll
well.
them by email and them by hand. In any event, if my learned friend is saying he has not received, I'll again serve.
When do you want it? Which Tuesday? Next Tuesday. What about you?
Next Tuesday.
What about
No, I don't have.
Learned advocate for the appellants seeks accommodation. Paragraph, learned advocate for the
Defendant number 2, 3, 4 in the suit. No, I don't know what.
different numbers 2, 3, and 4 in the suit says that his client has not been served with the appeal papers. Stop. Let service be paragraph. Let this matter be listed again on 16. না কবে 17 June 17 কেন জুলাই হয়ে যাচ্ছে বলো তো কারকারি June 17, 2025. So let service be completed in the meantime.
To an extent, the main we have served. This is the copy.
If it is not,
Why not I'll
give him another copy.
Definitely.
Yes.
On 17.
These are trivial issues, Mr. Go.
No, my lord. I never. That's why at the beginning only I said keep whatever I'll serve again.
17th, yes.
17th.
এই তোরা নন কমার্শিয়ালটা করে
কোনটা দেব
নন কমার্শিয়াল
তো ওই পাশে তো
না এইখানে কম্পিউটার এটা হচ্ছে 266 হ্যাঁ 266330 non-commercial item number 1.
Wasn't this substantially heard before the other bench?
Yes, my lord.
My lords,
My lord, I have also given my written notes.
Yes. We'll release this, take appropriate steps. We did with the Lamartinier matter also. Although not marked heard in part with inverted comma, this matter was heard substantially on several dates by a different bench. বলে আমার আর ওম নারায়ণ রায়ের নামটা দিয়ে দাও ব্র্যাকেটে paragraph, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. As soon as it is assigned, we expect it to be assigned, we'll assemble because Justice Rai is sitting singly, so it is easy for him to.
But we are not filing our notes then, Miller, today.
Don't file.
Grateful.
Today was fixed only for filing of notes.
If any clarification is required.
No. Then এই শোনো ওটাকে add করে দাও. Substantially on several dates করেছি তো? Stop.
Small thing. My lord, I was not fully heard because my lords were of the view that my note should cover everything. So in case anything is required.
My lord, I have already filed my notes in that event.
You are the appellant.
Yes, my lord.
The
My lord, hearing was
appellant has
concluded.
already filed its written notice of submission. Stop. Today was fixed for the respondent. Today was fixed for filing of the respondent's written notes and for finally hearing the respondent's
Hearing
counsel.
was concluded, my lord. I beg to differ, my lord. Because
If he wants to make
now if he
submission
comes
for
up with a new argument,
10,
my lord.
then if it's a new argument, we'll allow you to counter that.
Yes, my lord. Yes. My lord, we'll take steps for assignment, lordship. Grateful.
এই শোনো
Item number 2.
I put the petitioner.
have you served?
My lord, this is on restoration application, my lord. I have already served.
Restoration application.
Section 5 also, my lord. I have,
Where is your affidavit of service?
my lord, both affidavit of service.
কোনটা বাবা রেজিস্ট্রেশনটা বার করো না আর এটা সেকশন 5 আছে দুটোই বার করো affidavit of service কি তোমার? Yes. Which can is your condonation? 3 or 4? Which can 3 or 4 condonation?
My lord, 3, my lord.
No.
No, 4, my lord, for condemnation of delay, and 3 is for restoration.
From the affidavit of service filed in court today, we see that the respondents have received notice of the instant restoration application and application for condonation of delay. Stop. However, nobody appears for the respondents. Paragraph. Your can 4 now. Can 4. This is an application for condonation of delay of 63 days. In presenting the restoration application, stop. Causes shown being sufficient, the delay is condoned. Stop. Can 4 is disposed of. Can 3 to now. This is an application for restoration of FMA 567 of 2022, along with Can 2 of 2019, which were dismissed for default on December 17, 2024. Stop. Paragraph. Having heard learned counsel for the petitioner, we are satisfied with the explanation furnished for absence of learned advocate for the petitioner on the day the appeal was dismissed for default. Stop. Paragraph. Accordingly, the order dated is recalled December 17, 2024. Recall. Stop. FMA 567 of 2022 is restored to its original file and number along with the connected application. Next, Can 3 is disposed of. Next, appeal to now FMA ota niye bolo. Let this appeal be listed on June 17. June 17. Paragraph. Since the respondents are not represented today, learned advocate on record for the appellant is requested to communicate today's order to learned advocates for the respondents.
Number 3.
I am appearing on behalf of the respondent number 1, your lordship.
The last occasion, my lord, we had filed our affidavit in reply. They were supposed to file their opposition today.
May I file the affidavit in opposition, your lordship?
And my lord, the interim order is already existing till disposal of the stay application, my lord.
but a week's time may be granted, my lord. I am being led by Jishnu Chaudhary in this matter, my lord.
Your lordship, kindly.
Same case for the respondent also, my lord.
But have you checked up? This is this is challenge to an arbitral award or what is it?
No, your lordship. An ongoing suit, your lordship.
Yes,
Oh, I
ongoing
see.
suit. Section 8 application by me that was rejected.
Very well, very well. Affidavit in opposition filed in court today be kept with the records. Paragraph on the request made by learned advocate for the appellant, comma, let this matter stand adjourned and be listed again on
A week's time.
Any day next week, your lordship.
Next week. Any
next
day,
week.
Any day
Yes.
next week.
ওই জুন 16 করে দাও, লিস্টে দিয়ে দাও জুন 16 দেখা
with
যাবে।
alternate. Deeply obliged, bhai. Deeply obliged. Yes.
Item 4.
And I am appearing for the appellant, my lord, in this matter.
I appeal for the respondent number 1.
Well, this is the matter, your lord, my learned friend had on the last day taken the point of maintainability. This is an appeal from a section 8 rejection. Then appeal under section 37. The preliminary objection taken on the last occasion was, well, it has to be admitted under order 41 rule 11. That was the objection. And he had given citation of 2 judgments, my lord. And before going to the judgment, I will show your lordship the appellate side rule, the concerned rule. I think, my lord, the rule has been amended, and thereafter, my lord, it is no longer admission is required. The 2 judgments probably which my learned friend cited.
Mr. Tiwari had referred to chapter 5, rule 17,
Yes,
capital A and B.
I show your lordship, my lord, chapter 5, rule 17, A and B. My lord, B is relevant for our purpose, actually, my lord. Lordship, problem is I have only 1 copy of appellate side rule. Yes, yes.
Section 8 rejection is now appealable.
Yes, 37 appeal.
Yes.
I am personally not fond of these technicalities, you know. Absolutely.
Once taken, my lord.
Yes.
Appeal is an appeal. My lord, even
Yes.
if it has to be, suppose, my lord, it had to be admitted, your lordship will admit it.
If it's a statutory right,
Yes.
then where's the question of admission?
Even then, just adding to what fell from your lordship, my lord, suppose it is required to be admitted. What
Yes.
is the difference in the appeal that we filed from an injunction order under order 41 rule and the appeal we have filed here? The lordship, once your lordship is taking it up, your lordship is in the process of admitting. If your lordship finds in any appeal that it has no legs to stand, lordship will not admit it and dismiss it.
Followed.
So, my lord, your lordship will kindly see 17B.
বাবা এই কবেকারের আদিকালের বই দিয়েছে তো কিচ্ছু নেই।
I also did not find, my lord, in my book, my lord, ultimately, my lord.
তোমার আছে 17AB capital A?
Yes, my lord, 17B.
ঠিক আছে, দাঁড়াও। ওই ও দিচ্ছে, ওই যে দিচ্ছে যে ইজিয়ার। হ্যাঁ, না বলছি তোমাকে কোন সালের বই এটা? 2006।
Kindly keep, my lord, 2006 also, my lord.
আচ্ছা।
Then this amendment, my lord, your lordship will see it is within bracket. This 17.
So this is not 17 capital A.
No, 17 small a and small b.
Yes.
We are concerned with B. Kindly see, my lord, in case of an appeal from an appellate decree or an appeal and an order under other than an appeal under Workmen Compensation Act, an appeal from an order under Article 226, an appeal under Railways Act, an appeal under Motor Vehicles Act, and first appeal against deemed decree passed in execution, second appeal against deemed decree, all appeals under Section 39 of Arbitration Act, all other appeals under 37 of the Arbitration Act, except appeal under Section 37(1)(b), thereby setting aside an arbitral award. under section 34 of the Act admit it. So there is an express exclusion of certain appeals under certain statutes.
One second, once more. In the case of an appeal from an appellate decree or an appeal from an order, now this other than includes all the subsequent things.
Yes. Kindly see, other than an appeal under Workmen Compensation Act, comma, an appeal from an order under other 226 of the Constitution, these are all excluded. And that was the reasoning of Justice Seth's judgment. Whatever is excluded, admission is not necessary. If your lordship sees, my lord, that book, your lordship will find this 17 has been this 17A and B, there has been an amendment.
So all appeals under section 37 of the 96 Act are also excluded except
1B,
37 1B.
which is dealing with setting aside of award.
Correct.
And that setting aside of award, why it is not excluded? Because it is amounting to a deemed decree.
Right.
Award is amounting to a deemed decree. And previously, these deemed decrees are, that is why it has been brought within this fold of admission. Now, your lordship will kindly see in that book, your lordship will get this 17 is amended in 2009. Kindly see head note 1 in that
So
book.
the
And also
17
in that,
that Mr. Tiwari hands up
yes,
is an amended 17
yes.
notification dated 19 January 2009.
So this has come into effect in 2009. Kindly see before 2009, what was the provision, which is given just below, my lord, at the bottom of the page in the footnote.
In the footnote?
Yes.
Oh, yes, yes.
Here, your lordship will just compare this B and the amended B. In case of an appeal from an appellate decree or an appeal from an order other than an appeal under Workmen's Compensation Act, an appeal from an order under Article 226, appeal under the Indian Railways Act, and an appeal under Motor Vehicles Act. So these 4 acts have been excluded. Arbitration Act, Section 37 appeal was not excluded. So in 2003, when the matter was decided by the division bench,
yes.
Now, my lord, if your lordship sees the judgment of Justice Dilip Seth, 2000
pre-amendment.
Yes, pre-amendment. And paragraph 7 and 8 is very clear. If the act is excluded, only then admission is not necessary. That is what the judgment says.
And here it is excluded.
Here it is excluded. So this is, my lord, my submission on the maintainability aspect. Now, my lord, if your lordship kindly sees, this is a suit for, my lord, a lease arrangement. Jila Parishad, my lord, granted a lease arrangement in favor of my learned friend's client for running a medical center. It's like a nursing home cum diagnostic center on the terms and conditions contained in that agreement. There has been, I am not going into the merits. The allegation is that agreement is terminated because of breach committed by the respondent.
For running a primary healthcare center.
It is not like a primary head, it's actually a public-private partnership. It is my land, my space. I have given it to, on auction basis, I have given it to my learned friend's client for running a, like a nursing home cum diagnostic center, and they have to pay on payment of certain amount on the basis of their revenue earning. It's like a revenue sharing arrangement. That agreement has been terminated.
Rightly or wrongly terminated.
Rightly or wrongly terminated. My case is that there are several breaches, there are huge amounts due. I am no longer interested to continue. I have terminated this agreement. The agreement contains an arbitration clause. Now, Your Lordship, this is the perspective of the plaintiff.
Why has your Section 8 been rejected?
Because they have impleaded another party who is their alter ego, who has now got the contract after a fresh auction, after termination. Now kindly see the prayers. My lord, the question in a Section 8 is the substance of the relief claimed must be covered by the arbitration agreement. An incidental party or an incidental relief by addition will not take out the subject matter of the suit from the subject matter of the arbitration agreement. That is why I want to show Your Lordship that
There are decisions under the 40 Act.
Yes.
That by impleading a party who is not really a necessary party, you cannot defeat an arbitration agreement.
Well, that is under the old act. Now under the new act, after Section 8 has been amended by the group companies doctrine, well, this principle has been incorporated even in the Section 8 provision also.
Let us see Section 8 once.
Yes, my lord.
এই ওনাকে দাও সেকশন 8 এই সেকশন বলছি আরবিট্রেশন অ্যাক্ট দাও
A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement, this is the addition, or any person claiming through or under him, so applies not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. This is also the addition in the amendment, unless it finds. So, my lord, this part is the only restriction. The court has to come to a conclusion that prima facie there is an arbitration agreement covering the essential subject matter of the suit and the essential reliefs in the plaint. But why I am stressing on these essential reliefs, it is like this, if they have challenged the termination. So that is your primary relief. You have come to court challenging that termination.
Show us the prayers in the plaint.
Yes, that is what I am wanting to show. Plaint starts at page 27. The prayer Your Lordship will get.
Page 24 or 49. We have 2 page numbers.
49, my lord. Paragraph 34. Decree declaring that the deed of agreement executed on 9th July 2004 and a subsequent agreement between plaintiff number 1, defendant number 1 are still subsisting. Both are parties to the arbitration agreement. And this agreement contains the arbitration agreement.
And no relief is claimed against the defendant number
2.
2.
All these prayers, my lord, if Your Lordship will see, prayer C to E are all consequential to prayer A and B.
Yes.
So, my lord, when the suit court will be adjudicating prayer A and B, the entire subject matter of the arbitration agreement will be covered by those reliefs. So this is one of the only point which a Section 8 court is to look into. And once you are asking for declaration of that agreement as subsisting, automatically only the arbitration agreement, my lord, is also follows from there. It is not there, but there is no complicacy as such regarding any existence or non-existence of arbitration agreement.
Yes.
The learned court has only gone on the point.
Let us see the impugned order.
Yes.
First.
And my lord, a judgment has been relied upon. I will rely upon that judgment, which is completely different. My lord, your lordship will kindly see the impugned order.
21st March.
Yes, order number 14. Lordship can come to internal page 3 from the last paragraph.
We will just go through the entire. It's not only that your section 8 was dismissed,
Injunction has also been.
has been made absolute.
So
Your
much I have challenged that injunction by way of a separate appeal.
I see.
So order is severable in two parts. This order is restricted only to the finding and dismissal of the section 8.
Can you demonstrate from the papers on record that defendant number 2 in the suit is the alter ego of the plaintiff number 1?
Yes, in my objection, I think that point is there, my lord. Kindly have a look at the written objection.
Otherwise, there may be some difficulty.
No, I'll tell you, Lordship, my lord, kindly see. I'll come to that, my lord. But the point is, my lord, the subject matter of the suit. It is not concerned directly with a party. Suppose the subject matter of the suit also involves the other party, then obviously this point will be raised that whether the entire subject matter of the suit is covered by the arbitration agreement. Now here, your lordship has seen the plaint and the reliefs claimed. What is the subject matter of the suit, if I may ask this question to myself? The subject matter of the suit means what will be the issues which will be framed? Whether this lease agreement is still valid and subsisting. Whether the lease agreement has been rightly terminated or not. So insofar as the subject matter of the suit is concerned, and the issues which will be framed by the suit court, these issues will be directly covered by the arbitration agreement. Validity of the lease agreement, termination of the lease agreement, these are all issues which are encompassed within the scope of the arbitration agreement.
Mr. Tiwari, you are for the plaintiff. Defendant number 2 is not before us.
No.
Defendant number 2 is solved.
I don't know whether it has been served or not.
Have you not served the defendant number 2?
I'll just check.
Leela, what key? You know, now?
Well, number 2 is
Leela Hospitals.
Leela Hospital Private Limited.
Well, I'll just take instruction.
Please take. Otherwise, you have to serve.
Yes. Our defendant number 2 serve.
But so far as my preliminary objection is concerned, if your lordship kindly hears me on that aspect, whether it requires admission or not.
Yes, of course we'll hear you.
I find the pleading in the stay petition, it is there.
What?
Alter ego.
That making a pleading will not do, Mr. Sen.
No, section 8.
Who is in possession of the property now?
They are in possession. That is their advantage.
The plaintiffs.
Yes. I could not hand over to the auction, the auction successful auction bidder. And that is the injunction.
What happened to your appeal against
that is not yet taken, because my primary point is the section 8 point. It goes to the root of the jurisdiction. If I can't succeed here, then on the jurisdictional issue, I will not be able to succeed on merit in the injunction application. So, my lord, we had first preferred this appeal. Well, I don't think it has been served upon the defendant number 2. Because
no, you will have to do that, Mr. Sen.
Very well, but it is only between the plaintiff's suit.
The plaintiff, rightly or wrongly, the plaintiffs have asked for release also against the defendant number 2. For prayer B onwards, it is defendants.
Well, that is my submission, my lord. Your lordship will kindly see. What is the primary prayer, primary issue? Unless those are consequential, if he cannot get a declaration that the agreement is valid and subsisting, those prayers become redundant. So the primary relief, if it is covered by the arbitration agreement, that is what the test, subject to correction, my lord.
No, then you'll have to cite authority for that
Yes, my
also.
lord. I'll just show your lordship, my lord.
Or
First,
only after service.
very well, my lord. Kindly give a very short date, my lord.
Tell us.
কোথায় আছে এরা? Next week, your lordship will keep.
Yes.
Next week, my lord.
After we heard Mr. Shako Sen, learned senior advocate representing the appellant for some time, it transpires that the respondent number 3 in the appeal, bracketed defendant number 2 in the suit, closed, has not been served with the appeal papers. Paragraph, let such service be effected and affidavit of service be filed in court on the next date. Paragraph, as suggested by Mr. Sen, let this matter be listed again on June 17.
Obliged.
এটা থাকো।
Item 5.
FII appear for the appellant. Appealing for the respondent number 1. There's the caveat, man. I've served notice to the caveat.
On all the respondents?
No, man. Caveat on the abstract. Because he is the plaintiff. Man. As the appellant before your lordship, my lord, is the respondent number 1, my lord, the contesting respondent in the court below. By a composite order, a section 9 application ex parte order has been passed in section 9 application, my lord, and for unlimited period. And also, my lord, section 9(1)(c) application has been allowed appointing and commissioner, advocate commissioner. That also, my lord, finally disposed of. I have challenged that order before your lordship. The lordship kindly peruse the impugned order. This is that memorandum of appeal. The court, your lordship's court has always replicated ex parte order unless there is principle satisfied. This is not an ex parte, not only ex parte order, but also ex parte order for unlimited period. Ma'am, may I place the order?
We will read it.
And the appellant was not a party to the arbitration agreement. The alleged partnership did.
Appellant is not a party to the arbitration agreement.
Yes, and against him. He has made section 9 application, he has made the appellant as the party. Madhav was a partner, died 2010. Their case is they are running from 2010 till date. So there is no such urgency, my lord. I shall show it from the section 9 application. পরে
What happened on today is the 10th of
Today
June.
is because we have a challenge before your lordship's court, my lord, because
No, no, why have we go and appear before the learned
your
trial
lordship
court?
kindly see, my lord, the order, extend the interim order.
What extent?
Well,
You apply for vacating.
Well, that is there, man, but the order is wrong, apparent on the face of it, and your lordship series of judgment, my lord, since right from Chadda, Morgan Stanley, and my lord, other judgment, your lordship has seen when and how the ex parte ad interim order will be passed. But that is the principle laid
And
down.
how are you prejudiced? Would you want to alienate the property?
No, nothing, man.
Then
that is
that
not
is the
point.
only injunction.
Man, that is not the point. Man, why the court will pass an order which is not permissible under the law? Man, that is my point.
Go and apply for vacating.
Man, your lordship, man,
there is no such order as is hurting you very, very badly.
that is one. That is one point. Man, may I place, my lord, the judgment of your
But
lord?
is he not a party to the arbitration agreement?
Arbitration agreement, my lord, the original partnership deed, his mother was a party, my lord. He obtained a probate, and thereafter a suit was going on. The suit was in the suit he was substituted.
No. What is the nature of the agreement between him and you?
Partnership deed, my lord.
Partnership.
In a partnership deed, there was an arbitration clause, and this partnership deed is between his predecessor in interest. His mother was a party.
Right.
He obtained a probate. Prior to this arbitral proceeding, my lord, there was a suit. The suit was dismissed as not maintainable.
Whose suit?
My suit regarding the partnership. There was a dispute regarding the partnership during the lifetime of the mother. There he was substituted. Now, my lord, that suit was disposed of as not maintainable. Therefore, my lord, we use that clause, arbitral clause, for appointment of an arbitrator and injunction, my lord. Appointment of arbitrator, my lord, we are proceedings, my lord. We have already sent them a letter.
Is he a party to that partnership deed?
Partnership deed, his mother was a party.
Then how can you invoke Section 8 against Section 8 or Section 9 against him?
My lord,
unless he is admitted to the partnership as a partner and becomes a party to the...
He is claiming to be the owner of that particular partnership property, my lord.
He may claim anything, but where is an arbitration agreement between you and him?
My lord, the arbitration...
The partnership did not.
Or any party claiming under after Section 8.
20, clause 25. Parties to these presents.
Anyway, we need not enter into that. We leave that issue open.
But your lordship kindly stay the injunction order. Direct.
Why?
We'll fight before the court below. We are not afraid of fighting. Why there will be an order which is not permissible, the principle decided by your lordship's court and also by the Supreme Court. While that order will subsist in the judicial forum.
The learned court, after hearing them, was of the view that there is a prima facie case.
The conduct of the party.
You cite? What will you cite?
The conduct of the party, your lordship's court has held. You sit for a long time, not taking any steps. I am running the business as a proprietor, my lord. I have no privity of contact with him, my lord, and an expert identity model. I shall go
At the most, we can limit this order temporarily till a particular date and send it back with a request to dispose of.
I happily
we'll limit the order. No, we'll not interfere.
But even if the ex parte order is not permissible, my lord, subject to...
Sir, what is permissible, not permissible, leave that to us to decide. That is why we are here.
That is why, I am submitting. Your lordship has decided that this is not permissible under the law.
Every case turns on its own facts.
That is, my lord. That is right? There, my lord.
So therefore, no amount of authority is going to help you.
Because of the fact, my lord, the authority I want to cite before your lordship, my lord, your lordship's court has held that when and under what circumstances and considering what, my lord, the ex parte ad interim order will be passed. My lord, your lordship has seen. I have no really, my lord, your lordship has seen.
What prejudice are you suffering? Tell us.
Not only the case of prejudice, your lordship kindly sees, my lord,
That is also one of the
that
factors.
is also one.
We would have understood that you are suffering tremendous prejudice for this ex parte ad interim order, which was not warranted. We do not say any prejudice. You should go back. And we can't say that this is a totally unreasoned order or totally perverse order.
May I show 1-2 paragraph from the application, my lord? Once, my lord. My lord, because of this fact. But once, your lordship, I humbly pray your lordship kindly peruse, my lord, his application, section 9. I am placing, my lord.
Section 9.2 limits up to 90 days, my lord. Section 9.2 of the Arbitration Act, it limits up to 90 days, my lord. Interim measure.
Yes, which paragraph?
My lord, may I place it? And your lordship kindly peruse, my lord, paragraph. Paragraph 3, 5, and 6. My lord, paragraph 3 is, my lord, the need not read, my lord. This is the initial first, my lord, and then your lordship kindly peruse paragraph 5. That the paragraph 3 of the deed of partnership duly signed by Deepti Chandra reveals that the above referred investment through land towards capital contribution of the firm has been made by the first party of the deed of partnership, and thereby the suit plot became part and parcel of the firm, namely Kalyani Cinema Hall, wherein the entire capital of the investment of the petitioner and other deceased partner Abdul Ghani has been made in due course in terms with the partnership deed. Now, your lordship kindly peruse, my lord, paragraph 7. That unfortunately, Mr. Deepti Chandra died on 2010. Well, since 2010, they are saying that they are running. Well, in 2025, they are approaching the court and got an ex parte interim order. After long.
Yes, because you started obstructing him only then. That is their case.
No. Well, I am running. Well, no case has been made out. This is merely a statement.
Sir, a statement has anyway. No, I will not argue with you.
No, my lord.
Sir, we will limit the operation of the order, go back before the learned judge, fight it out.
But your lordship has record that
we will say nothing on merits. We will say nothing on merits. That may prejudice.
So for the appointment of commissioner, my lord, your lordship, that part your lordship can say.
Why? He will go and just prepare an inventory. We'll say so. He will not interfere in any manner.
Fishing out of evidence, your lordship knows, my lord, that Justice Chitratos Mukherjee judgment, my lord, Institute of Engineers.
Only advocate commissioner.
Yes, sir. Commissioner, the learned court may pass that order after hearing them.
Yes, sir.
That portion, we are not interfering with the injunction, but that portion we are setting aside because we are of the view that ex parte ad interim stage, that was not necessary.
Ex parte?
At the ex parte ad interim stage. You can renew your prayer in their presence.
My lord, but this is advocate commissioner, my lord, not engineer commissioner under order.
Doesn't matter. But already, maybe he has already, I don't know, we don't know.
No. They have filed
No.
They have that trial court, they moved it and
it has been adjourned till 26th of June.
My lord.
Issue.
And so far the limitation, my lord, my learned friend is saying, as per section 9.2 of the Arbitration Act, it is already limited for 90 days.
So 90 days is...
Kindly see.
It's Arbitration Act.
Check about it. Where before the commencement of the arbitral proceeding, a court passed an order for any interim measure of protection under subsection 1, the arbitral proceeding shall be commenced within a period of 90 days.
No, sir. No. This does not limit the operation. No, it says if in a case of pre-arbitration interim order under section 9, the arbitration will have to be commenced between within 90 days. That does not. No.
The arbitral tribunal.
That you may or may not. That is a different thing. This appeal is directed against an order dated April 8, 2025, passed by the learned district judge, HON'BLE, in Miss Case number 31 of 2025, being an application under section 9 of the Arbitration and Conciliation Act, 1996, filed by the respondent number 1 herein. Stop. Paragraph. The respondent number 1 herein approached the learned trial court contending that although he is entitled to and has been running a cinema hall since 2010.
No, cinema hall, yes, my lord.
Since 2010, the respondents before the learned trial court are unlawfully interfering with such right of the present respondent number 1. Stop. The learned trial court, upon considering the material on record, passed an ex parte ad interim order of injunction restraining the opposite party number 1 before the learned trial court. Is he the appellant here? Opposite party number. Being the appellant herein, from alienating the suit property or any part thereof, and also restraining him from creating any third party interest in respect of the suit property, and to maintain status quo in respect thereof. Stop. The petitioner before the trial court was directed to take steps for initiating arbitration proceedings, quote koro, as per rules, quote unquote. Stop. Paragraph. The learned trial court also appointed a learned advocate practicing in the Hooghly District Court as advocate / commissioner to hold local inspection of the suit property upon notice to all parties and to submit a report to the learned trial court. Stop. Being aggrieved, the respondent number 1 before the learned trial court has come up by way of this appeal. Paragraph. We have heard learned counsel for the parties for some time. Paragraph. Learned counsel for the appellant says that in the facts of the case, an ex parte ad interim order of injunction was not warranted. Stop. Nor should the learned court have appointed an advocate commissioner at the ex parte ad interim stage. Stop. There was no such grave urgency in the matter. Stop. Paragraph. Learned advocate for the respondent number 1 herein says that there was a real apprehension, there was and is a real apprehension of the respondents before the learned trial court, and in particular the present appellant, alienating the suit property, which would cause irreparable prejudice to the present respondent number one. Stop. Hence, the learned trial court was perfectly justified in passing the order that is sought to be impugned in this appeal. Paragraph. We are of the view that insofar as the order of injunction is concerned, comma, the same is not causing such prejudice to the appellant as would warrant immediate interference. Stop. The appellant would be at liberty to pray for vacating of the order of injunction before the learned trial court. Stop. In any event, comma, the order of injunction shall continue till the end of till আজকে কত 10ই তো till এক মাস দিন July 10
26th June they have fixed it, keep the date.
26 June
They have kept it.
till July 10 comma 2025 or until further order, whichever is earlier. Stop. It will be open for the learned trial court to vacate the injunction order or to extend the same upon hearing both the parties. Paragraph. Insofar as the appointment of advocate commissioner is concerned, comma, we are of the opinion that the same ought not to have been made by the learned trial court at the ex parte ad interim stage. Stop. We set aside that portion of the impugned order. Stop. However, comma, it will be open for the respondent number one herein to renew his prayer for appointment of advocate commissioner or make any other similar prayer before the learned trial court, trial judge, who is requested to consider and decide such prayer in accordance with law upon hearing both parties. Stop. Paragraph. The learned trial judge is requested to dispose of the injunction application, dispose of the application under Section 9 of the 1996 Act in accordance with law, comma, without being influenced by any observation made in this order, as we have not gone into the merits of the case.
And your lordship kindly record the prima facie no existence of agreement, arbitration agreement between the parties.
Paragraph. Learned advocate for the appellant says that he is not a party to any arbitration agreement.
And not running the business since it is running.
Who is not running?
The cinema hall is running by the appellant before your lordship.
Stop.
At this point,
We are not deciding anything.
Only submission is being recorded.
The further the party to any arbitration agreement. Stop. Therefore, comma, no question of referring the disputes to arbitration or can arise. Arbitration can arise. Stop. Consequently, comma, an application under Section 9 of the Arbitration Act would also Arbitration Act 1996 would also not be maintainable. Stop. He further says that it is the appellant who is running the cinema hall
since 2018.
In 2018.
18.
Since 2018 and not the respondent number one herein. Stop. Paragraph. Learned advocate for the respondent number one disputes each and every submission made above, made on behalf of the appellant as recorded above. As recorded above, paragraph, we are not deciding the disputes indicated above. Stop. Learned trial court is requested to decide all such disputes. Paragraph, the appeal and the application.
না আমি বলছি কপিটা দেবেন পার্টনারশিপ ডিডের কপিটা may I take back the copy of the partnership?
Yes, take back.
Grateful to you.
Item number 6.
Well, 6th time for the appellant, my lord. On last occasion, Mr. Kaushik Bhattacharya was appearing. He did not have his Wakalatnama. That matter, lordship told him, kindly apprise the court on the next day what you are going to supposed to do. Today also he is not there.
What should we do? You tell us.
No, well, whatever.
Yes.
It's a matter of 2008.
Yes. You want to proceed ex parte? We can hear you.
As a last chance, may I give him a notice? Ki korbi? Ex parte korbi.
Order korbi to otherwise ex parte hearing. Order korbi.
Makes an order to that effect. If he does not come, we might proceed ex parte.
কিছু অর্ডার আছে আগের দিনের?
The last day, just simple as the order, I said adjourn till 9th. But that was the issue on that day.
The respondents are not represented. Stop. This is an old appeal of 2008. Stop. Paragraph. Learned advocate on record for the appellant is requested to serve a notice on learned advocate for the respondents, intimating that this matter will be listed again on June 17, 2025. Stop. If on that date the respondents are not represented, this appeal is likely to be heard ex parte, heard and disposed of ex parte. Who is your advocate on record? Please say.
Mr. Banerjee. আসুক না এলে বলবো
Item 7.
In this matter, my lord, I am led by Mr. Suman Sengupta. My lord, he is suffering from an eye infection. He is difficulty having reading. My lord, kindly, my lord, keeps it.
My lord, I am not opposing, but your lordship's last order, your lordship will see, my lord, 2006 award, section 34 dismissed. Then, my lord, the appeal, they preferred the stay petition here, 2013. So 2013 to 2024, the matter was again dismissed for default in 2024. Ultimately, your lordship restored it on the understanding that after vacation, the matter will be heard. My lord, can my learned friend give a date?
My lord,
when they will proceed?
any date, my lord, as your lordship pleases, my lord, preferably after 2 weeks, because my lord, he is not able to read properly.
Give us, tell you discuss.
2 weeks বাদে আপনি বলুন, বলা বল।
2 weeks মানে আজকে কত 10 24 24th. Learned দেখো, learned advocate for the appellants says that learned arguing counsel for the state is indisposed with eye infection. Stop. As requested by him, let this matter stand adjourned and be listed again on June 24, 2025. Stop. it is understood that on the adjourned date, on the next date, next date, no adjournment will be sought for
Very well.
by
I'm grateful.
either of the parties.
I'm grateful. I'm grateful. Indeed.
Item 8.
And for the appellant, uh, my lord has been pleased to hear this matter before the vacation. On
Yes.
Your lordship was pleased to hear this matter before the vacation on the section 37 appeal. Section 34, the three partnership firm accounts were given, and there were discrepancies. Then the then a expert was appointed. Expert given a report, and on the basis of the report, award was passed. Lordship had been pleased to hear the matter.
Oh,
Mr.
this
Dev
was heard. This was heard at length by the other bench.
Yes.
We'll release this, and it will be listed before the other bench.
The other bench.
You have to get it assigned, sir.
Yes.
Otherwise, it will be a waste. 3 or 4 days we heard this matter.
Yes.
Mr. Shudip Dev was
Mr. Bordhan was leading me. Mr. Dev was on the other side. Lordship heard Mr. Bordhan at length, and then Mr. Dev.
So now you will be in reply.
I will be in reply. Yes, that was our initial submission. Mr. Dev had then responded, and then we will make our
in reply. So the hearing is almost on the verge of conclusion.
Yes.
Although not marked, heard in part within inverted comma. This matter was heard substantially by another division bench, bracket আমাদের দুজন আমরা রোমের নাম দিয়েছিল, হ্যাঁ, on May 20, 2025 and May 23, 2025. Stop. It has been listed today. No, 25. Stop. It is only the appellant will make his submission in reply. Now, paragraph. In that view of the matter, let this appeal stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. You write a letter to the OSD.
That bench has to be.
Yes, any day once you get the assignment, because Justice Rai is sitting singly.
Yes.
Very easy for us to assemble.
Yes.
One in item number 8.
Respondent number 1. In item 8, we have just allowed the appeal.
Yes. Prepared a supplementary affidavit.
Item number কোনটা ডাক হলো এখন? এইটাই তো।
88 তো, 88 তো।
হ্যাঁ।
Supplementary affidavit.
We have prepared a supplementary affidavit annexing the report of the learned arbitrator.
Anyway, it's released from our list.
Released.
Chalo, rakho. Take steps and have it
Let's
assigned.
take steps. Right, sir.
Item 9.
This is I'm for the appellant.
Yes.
The award was in my favor. Award was in my favor. I am the contractor. The widening of a road in Purbo Mednipur. May I just tell your lordship shortly the
award has been set aside. Award has been
set aside in section 34 application. Now, regarding scope of application under section 34, the ground, there are various decisions, and I shall only rely on 2 judgments. That's all. My humble submission before your lordship is that the learned arbitrator, upon construction of the clauses of the agreement, has found that show cause notice was not used by the superintending engineer. So, the imposition of penalty and termination of contract are bad. So this gives rise to my entitlement. Regarding quantification of the claim, on the basis of the principle laid down in Dismissal, 84 Supreme Court, that contractor was prevented from performing the rest of the work. So the balance portion of work, 15%. The amount of compensation the contractor is entitled. That has been followed. So in the quantification part, there are two subheadings. I'm trying to be as precise as possible. That the principle is as laid down in bridge policy, 15% of the balance work. And the calculation part of it, the learned arbitrator has calculated. Suppose the contractor has said, actual figure will appear from the above.
Did you fix আছে নাকি? Fixed নাকি?
My lord, suppose I have to complete work for ₹100. I say that I have completed 60% of it. And I have claimed 40%. 40% on the portion of balance work and 15% on the 40%. That was my calculation before the learned arbitrator in the statement of claim. In the counter statement of fact and counterclaim, the respondent has stated, no, the claimant has done only 20% work. Learned arbitrator has accepted the statement made by the respondent. So instead of 100 minus 40, the balance portion, it has become 100 minus 20, 80%, 80 units. And 15% on that has been calculated. Only one and only one head has been allowed. That is my loss of profit. Now, in short,
what is the award amount?
Awarded amount, Your Lordship, kindly give me a moment. 59 lakhs and odd. $59,31,032. Your Lordship will find that in 414 in volume 2. পেজগুলো বলুন।
The paper book.
Claim, Your Lordship will find at page 422. আমার বুকটা কোথায়? Page 422, Your Lordship will find my claims.
Yes.
And I think claim number 3 is at page 422 on account of loss of profit. Kindly concentrate on this because other claims are not allowed in 34 application or from appeal thereof. I cannot challenge that.
Yes.
So this was my claim. Now, against that, written statement. Miller, kindly come to page 485.
490 is the final award.
490 is the page.
Yes.
Yes. বলো বলো দেখো নম্বর ঠিক ওটা বলো
Why did the 34 court set aside the award?
Main ground is regarding my entitlement. It was the view of the 34 court that the decision of the learned arbitrator on construction of clause 2 and clause 3, and he has followed also that old decision of 36 Privy Council to the effect that if that was in case of a statute, if a procedure is prescribed, that has to be followed.
Nazir Ahmed.
Nazira. So here the superintending engineer was to, my lord, impose penalty. And the show cause notice was given by the executive engineer. The detailed discussions or submission has been recorded in the award. I need not read out. I am giving the principles. So this is upon construction of the clauses of the contract, clause 2 and 3, page clause 2 and 3. Lordship will find clause 1571. Huh? 157. At page 1571. No, no, clause 1571 and 1572 in volume 6. I am trying to be as brief as possible.
We will have to see the award. We will have to see the impugned judgment.
But this is the background.
This is which court? 34 court? Which court? This court?
Tumnu court. Before going to my lord the order under appeal, award and order under appeal, I am just pointing. Clauses 2 and 3 are at pages 1571 and 1572. Okay.
This was heard by any previous bench.
It was
all
hard
page
one.
marked.
No.
This is sense bench.
না না সেন্স না এখানে না না এখানেই তো হয়েছিল
Before
on
us,
One day.
one day, Justice Rai was there.
right.
Very well. 1571.
Yes.
1570.
Which clause, Mr. Ghosh?
Clause 2 and clause 3, 1571 and 1572. Now I must tell your lordship one thing. I have tried to find out. Milord, there is no specific provision of
এই এসিটা কি নিভিয়েছো? বললাম নিভিয়ে দিতে। মুখ খোলা আছে তো দেখতে পাচ্ছি। Yes.
Milord, পাখাটা বন্ধ। এটা খোলা বন্ধ। This one, no, it's creating problem because outside is too much hot.
Outside 50 degrees.
Now, there is no, it's my duty as a lawyer to point out to your lordship, there is no specific provision in the contract regarding issue of any show cause notice. Clause 2 says that in such and such situation, your lordship will find from the clause itself, and the superintending engineer will impose penalty. But in the present case, the executive engineer issued the show cause notice that you have not done this, there is delay, etc., etc. But the ultimate imposition of penalty was done by superintending engineer, and the termination was done by executive engineer. Now, on that basis, this is the basis of my entitlement. On that basis, it has been held by the learned arbitrator, in the award, that termination is bad. I was prevented from executing the balance portion of the work, and accordingly I am entitled to get the admitted amount deducted, which according to the respondent has been done by the claimant from the value of the work, 15% on that. The learned court dealing with section 34 application, my lord, is of the view that this, I should say, the reasoning is not acceptable to him. Though in my most humble submission, it is interpretation of clause of contract. In the Renu Sagar case, old case, error within jurisdiction and error of jurisdiction, the difference. That those two phrases have come across the cases in the 96 Act also. So, if at all,
error within and error outside without, wasn't it the anismenic case? Original, that English House of Lords?
That has been followed here. And error within means this is the ambit or the scope of the jurisdiction of the arbitrator. He has committed some error. Error of jurisdiction means this is the ambit, he has gone behind that, beyond that. Now, there are various decisions on principle of law that if the arbitrator, even in 96 Act, comes to a conclusion upon interpretation of clauses, two things cannot be touched. Appreciation of facts, unless it is perverse, absolutely, and the interpretation of clause, one possible view or plausible view that can be accepted by, that should be accepted by court. It is not an appellate forum. Main thing is that court may come to a different finding in the facts of the case, but this is not an appeal.
Yes.
Now, before Milord going further, may I humbly place before your Lordship or point out to your Lordship the relevant portions of the award and the order under appeal. Kindly take the award. Page 482 in paper book 2. Award starts at Kotobo. It is a very longish award because all the claims and counterclaims have been dealt with. 414 is the first page. And if you kindly come to, I am omitting below the narration part, claim, counterclaim set out, and the submissions recorded. Kindly come to page 482, internal page 69.
Yes.
imposition of clauses 2 and 3 of the contract. And this is the reasoning in page 483, termination of contract. May I just point out the heading?
Yes. Yes.
And then the decision starts at page 484. Kindly come to claim number 3 at page 485 to 486. These four pages.
Yes. So this is the only claim that was allowed.
This is the only claim that was allowed.
Pritpal Singh is 84 Supreme Court.
I have that, my lord, already explained. And I shall rely on two decisions. One is Associated Engineering of 2015 Supreme Court. I'm giving the Miller citation. Another is the same thing is continuing till today, 24th Supreme Court, I believe, Hindustan Construction. The scope of the, I think these are the Miller, the reasoning of the learned arbitrator in the award. On the basis of interpretation of clauses 2 and 3. Another aspect I should point out, in the impugned judgment, it has been observed that the learned arbitrator has not considered the notices given and the reply there. Those documents are there, were there before the learned arbitrator. I can give the pages also. কোন page বলে দাও? হ্যাঁ, একসঙ্গে বলে দাও তাহলে। না কি দেখাচ্ছ ডকুমেন্ট 1.5 those notices, because if those are not considered, then the award would be perverse. That's why my duty to point out that those are.
Mr. Ghosh, will you request your learned junior or advocate on record to make a bunch of the documents you want to rely upon, given that there are how many volumes?
Volumes of 1600.
Yes. Just 5, 6, 10 documents which you wish to rely upon. That will help us.
Yes. And Miller, all other portions of the award and
award
the
not necessary.
And the clauses I shall give.
Clauses or whatever that notices and replies with the page number of the paper book where it appears.
These days in arbitration they call it convenience volume.
Correct. Here also we are calling it convenience volume.
আচ্ছা অর্ডারটা বার করো, ঠিক আছে বললেন তো জাস্ট ওই টাইম ওয়েস্ট করে লাভ নেই। 1492 ভলিউম বলো।
ভলিউম 6 ভলিউম 6 1490
এখানে
in fact I have refused to open the paper book since the note, all the notes are in my iPad.
1492 is the impugned judgment.
Volume 6. Oh, I should point out one thing. There were two applications under section 34. That is why there are two appeals in the list.
Why two applications?
Because first, the State of West Bengal filed section 34 application. That was heard first. This is the judgment passed in that application. Here, our claim, only one claim which was allowed, that was rejected, and nothing is, held in favor of the respondent because their counterclaim was also dismissed. 34 court cannot say anything. Second application was my application under section 34 for rejection of our
Other claims.
Other claim. That was consequently dismissed. So I am making submission mainly on the application made by the state award. Ninth August 2019. Kindly keep a note that this is the judgment made in application filed by state appointment. And corresponding to which is appeal number. List appeal number koto.
Is there a separate judgment in so far as your section 34 is concerned?
I am not troubling with lordship with that because this is the main.
So you really not be pressing that appeal that much?
Because in view of this judgment, the other judgment was passed.
No. Even if you succeed, let us say you succeed in this appeal, then you get back your 59 lakhs.
Yes. No, because
the other claims, are you pressing or not?
It is very pertinent query that fell from your lordship. I have been instructed to do so. Kindly do not record. But as a lawyer, I feel my hands are tied.
Very good.
I can say thus far. Kindly do not record that I have considered anything.
No.
Since I am relying on some judgment in the first appeal, which will restrict the scope of challenge, I cannot say that in my appeal it should be widened. বলো claim number 3 কোথায় বলো কোথা থেকে বলো শুরু বলো Now, these kindly come to 1501. Page 1501. All the judgments have been set out here. Your lordship will find in the last judgment associate builder possible view of the arbitrator. That is also noted at the bottom of the page.
Associate builders.
Yeah. Then kindly come to page 1502 in the middle. Imposition of clauses 2 and 3 of the contract. I am not reading out the entire thing.
No.
Then clause 2 is quoted here at page 1503. Clause 3 is quoted at page 1504. Now kindly come to page 1505 towards the bottom. On perusal of the entire material, the last paragraph.
Yes.
As placed before this court, it reveals to the court that admittedly under cover of the letter dated 17th April 2012, the executive engineer, PWD, etc., issued a so-called notice to the respondent asking the said firm to assign reasons as to why clause 2 of the agreement between them shall not be invoked. But by issuing the said letter dated 17/4/2012, executive engineer never invoked clause 2 of the agreement between the parties. On the basis of the material placed before this court, it reveals is that to this court that subsequent to issuance of letter dated 17th April 2012 by executive engineer, the superintending engineer, Southern Division Statute, by issuing his letter dated 1st June 2012, practically invoke clause 2 of the said agreement. Practical, it means nothing. Said agreement whereby they ask for the respondent firm to pay compensation. So the last portion of clause 2 is this letter, imposition of penalty. Our grievance was it should be the same authority who should issue the so-called notice. I shall give reason. If it is not accepted, he can take steps.
Will you continue after recess, Mr. Ghosh?
Should I come ready with those papers? I think that will
As
be-
you wish. We are happy to hear you after recess. There's
Oh.
not much in it, really.
No. People
You will complete today if Mr. Ghosh concludes.
Come back next day, Thursday, my lord.
Then you come back. No point. Mr. Malay Ghosh, Mr. Malay Ghosh, from a learned senior counsel, representing the Akshangi Kuru, the appellant in both the appeals, begins his submission but does not conclude. Paragraph as requested, list these matters once again. Thursday. Purshu. আজকে লিস্টে
না এটা করতে পারছি
দুটো পেপার বুকই হয়ে যাচ্ছে ভলিউম
না না কাগজগুলো ঠিক আছে
পেপার বুক লাগছে এটা এখানে
না
এই শোনো এটা অ্যাড করে দাও as the first two items under the heading for hearing, since this is a continuing matter. ঠিক আছে বুঝেছো কৌশিক হিয়ারিং এর উপরে থাকবে এটা নাও থ্যাংক ইউ
Item number 11.
I appear for the respondent, my lord.
My lord, I appear for the appellant.
In this matter, on the last order of this honorable court was that, my lord, there was to be an application filed for condonation. That has not been filed as yet, my lord.
Right, it was
The
filed.
court had stated that the appeal is not maintainable otherwise. It fell from the court itself, my lord. But we have not been served with any application for condonation of delay, my lord, till date.
Condonation application has been allowed. What is this?
But we have not been served even.
The other previous division bench, look at this order. এটা দেখাও নাকি?
If that has been, my lord, allowed, then I can't say anything. But, my lord, this was.
It was not served.
We don't have a copy of it, my lord. Anyway, my lord, if it is the order records it, then we have served. We have a
Oh, it records your name.
at least I have never appeared on that.
And Mr. Loknath Chatterjee.
Both of us did not.
We'll have to take.
You have lost weight.
Literally, not figuratively. I believe so.
I believe in every way, my lord. It's good for him.
So what do you propose to do? Tell us.
I'm ready with the matter, my lord. It's a very short point.
Yes, you are for the appellant.
I'm for the.
Yes. Let us, as is our habit, let us go through the impugned order once. (25th September 23). Impugned order.
Yes.
হ্যাঁ আছে 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 পরের পাতাতে পরের
So the arbitrator, who published the award, was appointed after the 7th schedule was introduced to the Act.
Yes. It's a very short point, my lord, whether, my lord, a person connected with the, my lord,
Yes, that's what the
institution
7th
can be
schedule
appointed.
says.
He was serving even. The law now is well settled.
That's absolutely well settled.
Yes.
How do you defend it?
Now, my lord, kindly consider.
We need not go into the merits.
No, my lord, even on the first point,
Yes,
there was no section 16 application filed.
not necessary.
Now, the respondent has submitted within the jurisdiction of the learned arbitrator, accepting his appointment. Kindly see, my lord, there was a disclosure also when the newly Mr. Yadav, the learned arbitrator who was appointed, the first letter which was sent, the notice which was sent to the parties.
7th schedule is referred to in which section?
Section 12.
Section 12 kindly takes, my lord, once. Okay. My lord, kindly comes to the explanation which talks of the, my lord, 6th schedule. And my lord, kindly sees, my lord, subsection 5, it talks about the 7th schedule. 12.5, subsection 5. Cannot be an estoppel against a statute, my lord.
No, but then proviso.
Right.
Yes. Yes, kindly sees the thing, sees the proviso. There has to be an express agreement in writing. And we had filed an application, my lord, to the extent that he shouldn't be, my lord, considered. Maybe not correctly worded, but there was an application. And my lord, there has to be an express agreement in writing. There is no agreement in writing.
If in writing you accept this appointment,
I have not, my lord. I have not. That is my challenge which has been upheld. I have enclosed, that application is also enclosed. I have not. That's exactly why I am saying, my lord, I do not fall under the proviso. Oof.
And if my
I do not fall under the proviso.
place that application was my learned senior friend is referring, Velocity sees that application.
yeah, where is it? Where is that application?
That is at, my lord, 365.
365?
362, it starts volume, my lord, 3. Kindly sees 365. And, my lord,
starts from page 360.
Paragraph, as I said, it may not be correctly, my lord, worded, or the nomenclature is not correct at the heading. But kindly sees paragraph 14 at page 368. 368, paragraph 14. Heading is determination of, my lord, amount. Maybe. Kindly comes to paragraph 14, page 368. 367, paragraph 8, I have stated who he is, and he is still, my lord, working. And kindly sees paragraph 14. In such circumstances, a claimant prays that the learned soul be pleased to make he is not in any way connected with the issues in consideration in the instant arbitral proceeding, and fix a reasonable amount of fees be said. So, I have already asked for that declaration. And at 369, I have a specific prayer at prayer B. The learned sole arbitrator be pleased to make a declaration that he is in no way, not in any way connected with the issues in consideration in the instant arbitration proceeding. And that's the law settled now, my lord. He should not be in any way connected, my lord, with the appointing authority or, my lord, the, my lord, institution, even in any manner. Now it's, my lord, explained very clearly, my lord, whatever, my lord, discrepancies were there in the earlier judgments have been all been.
Before you took out this application, you participated in the settlement of issues also.
Even if I participate, the moment I, my lord, raise this issue, my lord, now, my lord, even raising of an issue is not required because, my lord, the law is settled now because it says, my lord, no way it should be, should be connected. Even he participates, my lord, still, my lord, it can go. But I am not even on that. Even if issues are framed, the moment, my lord, I take out an application with a specific prayer, my lord, he has to decide upon that. This application, my lord, has not been disposed of. That was my argument before the learned trial court.
Anyway, let us read the impugned order.
Yes, ma'am.
Yes, sir, you can make your submission now.
Yes. Now, so far as the first point is concerned, section 12, subsection 5. Now, section 12, subsection 5 has two issues. One is any person who has been appointed as an arbitrator should furnish a disclosure, should furnish a declaration. That is subsection 5. Now, so far as the connection with the dispute or related with either any of the parties, so far as that issue is concerned, parties are at liberty to waive. So far as waiver is concerned, now kindly considers the declaration which was submitted. Page 72. After this learned arbitrator was appointed, representing the earlier arbitrator, the first notice which was issued, page 72.
Paper book.
Paper book file.
72 thou?
First one. Volume 1 and 2, part 1. This notice was issued to the respondent also, to the claimant, the appellant as well as the respondent.
দেখছেন সেটা সাপ্লিমেন্টারি আপনারা যেটা দেখছেন সেটা সাপ্লিমেন্টারি
No, your losses has got a letter of 29th of June 2016, my lord. Now, here the declaration is given. There, I declare that there are no circumstances liable to give rise to justifiable doubts as to my impartiality or independence.
Yes.
Now, disclosure is required not under subsection 5. Disclosure is required under subsection
1.
1. Subsection 1, disclosure required. Now, your losses has seen the impugned order. It is not on the ground of disclosure. It was on the ground of section 12, subsection 5. So far as section 12, subsection 5 is concerned, the proviso says the parties are at liberty to waive off that the application of subsection.
No, not as simple as that. Agreement in writing has to be an agreement in writing.
Now, Mindla kindly says the
Now, do not cite cases of waiver by conduct, waiver by estoppel, not applicable.
In writing.
Agreement in writing.
Now, so far as that application is concerned, now this notice was sent on 29th of June 2016. Now, after this notice was received, kindly see the next page, there are certain things yet to be done, which were scheduled thereafter, after this notice of 9th July 2016.
What is the date of that application that you filed?
In October, after this declaration, I made this application, which was not disposed of. Kindly seize, my lord, verification page 3.
Horribly drafted application.
Yes, horrible. But 20th of October 2016.
Well, this application, in my humble submission this application is not under challenging his jurisdiction.
Sir, forget about the application.
My lord.
Assume the application is not there.
My lord.
Show us the agreement in writing whereby the parties accepted Mr. Yadav as an arbitrator.
Now, if license kindly sees page 72 once that letter.
Yes.
At page 73, there are certain directions given which were to be done by, which were to be complied by the parties to the
Yes.
proceedings. One is filing of the reply to the counterclaim of the respondent by claimant, which is to be done on by 9th of July 2016. Thereafter, rejoinder by 22nd of July 2016, and thereafter draft issues by 30th July 2016. Accepting this direction, the respondent both the parties complied with these directions. Now, when the parties have complied with the directions of the learned arbitrator, the parties have waived the challenge so far as the section 12 subsection 5 is concerned.
Very well.
Now, kindly see the application also, which was filed much later to this direction in October 2016, after completion of all the pleadings. Now, in these applications, kindly see the prayers. What was the prayers which were raised? The learned sole arbitrator be pleased to fix a reasonable amount of fees. So, fixation of fees will only arise when the appointment is accepted. When the appointment is accepted, only then the question of fixation of fees will arise. So when the respondent is seeking a direction for fixation of fees, the respondent has already accepted the appointment. Now kindly see the next prayer to make a declaration that he is not in any way connected. The declaration has already been given earlier. I have shown to your lodges. Then the cost of the applications. Now, like kindly see the written notes which was also submitted before the learned arbitrator. Kindly see the written notes. Now, written note starts from page 373 of volume 3. Supplementary paper book, volume 3. The volume where that application has been annexed starts from page 373.
When was this filed? No date is given.
17th of May 2017. The postal receipt is at the top one.
May 2017. And your application is October 2016.
Yes. Which was not disposed of.
Yes.
Now, my lord, in that here also at page 433 it has been mentioned that at page 433,
433.
para 46 of the written notes.
Page 433, yes.
Para 46. It was also fit and proper that the learned arbitrator had made a declaration that he is not connected with the issues in consideration in the instant arbitral proceedings. Is this submission on the part of the respondent?
Yes.
Thereafter, he pressed for the claims. Seeking that the declaration that the termination was wrongful. Then for a restoration of the distributorship and the amount which is to be recoverable for the damages and all. These are the praise. So when the appointment was made, it was duly communicated. After the communication, certain pleadings were also exchanged as per the direction of the learned arbitrator. When the pleadings, whether the direction was given, a disclosure was made, and the parties have agreed, submitted within the jurisdiction of the learned arbitrator. In my humble submission, my lord, the point of jurisdiction cannot be raised at a later stage.
Anything more?
And so far as on this particular point, my lord, if you lodge there are other grounds on which it was also set aside on the merits of the cases. And also, my lord, if losses may kindly also sees that application also, the application which my learned friend has placed. If he losses sees that application, in that application, may I place, it's a short application, may I place, the claimant, page 365.
Yes.
The claimant, who had been a distributor of the respondent corporation liquefied petroleum gas known as Indian in cylinders for consumers in the territory distribution area of Narkatiyaganj, West Champaran, Bihar. The claimant has initiated the instant arbitral proceedings and has made certain prayers as would be evident from the statement of claim filed by the claimant. Initially, Sri S. Balasubramaniam had been appointed as the learned sole arbitrator. The erstwhile learned sole arbitrator had inter alia issued directions for filing of the statement of claim, statement of defense, and rejoinder. Pursuant to such directions of the learned sole arbitrator, the claimant had filed its statement of claim. The contents of the statement of claim are all true and correct. The claimant craves leave to refer to the copy of the statement of claim at the time of hearing if necessary. The respondent had filed a statement of defense and had thereafter submitted a counterclaim in addition to the statement of defense. The allegations in the same are not true and correct, which the claimant craves leave to demonstrate at the time of hearing if necessary. So here also proceeds with the reference and leave is been craved for placing all the documents on the merits of the case at the time of hearing. The claimant had thereafter filed his rejoinder, the contents of which are true and correct. The claimant craves leaves to refer to a copy of the said rejoinder at the time of hearing if necessary. However, even before the pleadings in the matter could be completed, it was intimated that the present learned arbitrator had been appointed in place and stead of Sri S. Balasubramaniam. It has been learned that the present learned sole arbitrator is the ED Automation, having his office at ISL head office, Indian Oil Bhavan, G9 Aliyavar Gang Marg, Bandra East, Mumbai, such and such. It has been learned that the present learned arbitrator is leaving his office in Mumbai and visiting all the way to Patna for the present arbitral proceedings, which is inter alia commercial in nature. A sitting was held on September 30th of 2016, wherein the issues were settled by the sole learned arbitrator. The claimant craves leave to refer to the minutes of the arbitral proceedings at the time of hearing if necessary. It is stated that the present arbitral proceedings is inter alia commercial in nature.
We have read it.
So this is only for the entire, all the statements made in this application goes without saying that the respondent has accepted the appointment and submitted within the jurisdiction of the learned arbitrator. The only thing which is reflected in this, only thing which was sought for is fixation of the fees, because the venue is in a partner. He was all coming down to partners. That's why he should be adequately compensated. So the remuneration should be fair.
Yes.
Now, my lord, kindly sees the other grounds on which the award was set aside. So far as on merits are concerned, the first ground is there were altogether 16 issues which were framed. Now, while passing the award, the certain issues were clubbed together and those were decided. According to the learned judge, the issues were not properly dealt. All the issues were not properly dealt. One of the content and it has been said that the findings are contrary to the materials available on record. There was no evidence on the basis of which the findings were arrived at. However, my lord, there was no discussion why. There was no reasons given why the findings are contrary to the record, or why the findings are contrary to the evidence available on record. The reasons are not there. The one of the reason which was given on the merits, saying that the show cause notice, the show cause for termination notice was issued by a person who was not authorized. Then however, I will show from the pleadings, this point was not taken. In the statement of claim, this issue was not taken. So far as the jurisdiction of the person concerned, this issue was not taken in the statement of claim. Now, my lord, the other issue which was, and all these issues were dealt with, because this was one issue which was not even for consideration before the learned arbitrator. The learned arbitrator has no occasion, even the respondent has no occasions to.
Sir, before going into the merits, let us thrash out this point. This is a point of some importance. Mr. Banerjee, please, if you can show us authorities that even after participating in the proceedings without any objection, participating in the settlement of issues, taking out an application for fixation of the remuneration of the arbitrator, even thereafter, the party can rely on section 15(5). We find it difficult to accept, but not 12(5). Sorry, 12(5). Yes.
I will, my lord, show the, my lord, decisions, but my lord, I want to just, my lord.
If you have the decisions with you, fine. Otherwise, we'll give you time. If you succeed on this point, we need not go into the other points.
Correct. Absolutely correct. I'm on that only which the trial court has.
Therefore, let us address this issue first. When will you come back? Tell us.
Tomorrow itself.
Tomorrow.
Yes. Tomorrow itself.
One of the points involved in this appeal under section 37 of the Arbitration and Conciliation Act, 1996 is whether or not the learned trial judge was correct in holding that the arbitrator was incompetent to pass an award in view of section 12(5) of the arbitration of the 1996 Act, read with the 7th schedule thereto. Stop. Paragraph. Learned advocate for the appellant argued that after coming to know of the appointment of the arbitrator, namely Mr. Sri Yadav, comma, knowing very well that Sri Yadav was an employee of the appellant, comma, the respondent oblique claimant participated in the arbitration proceedings, comma, complied with the directions of the arbitrator, and even, comma, arbitrator, comma, participated in settlement of issues in September 2016, and even went to the extent of taking out an application before the learned arbitrator, inter alia, for fixation of the remuneration of the learned arbitrator. Stop. The claimant continued to appear before the arbitrator and also filed its written notes of arguments at the end of the hearing. Stop. After this, comma, the claimant cannot be permitted to rely upon section 12 bracket 5 of the 1996 Act, read with the 7th schedule thereto. Paragraph. Mr. Banerjee, comma, learned counsel representing the respondent oblique claimant, says that there can be no estoppel against statute. Stop. The application made by the claimant before the arbitrator was also for a declaration to be made by the arbitrator that he had no, what was the language used?
Connection with the
No connection with the issues involved in the arbitration. Stop. That application was never disposed of by the arbitrator. Stop. In any event, comma, no degree of participation in the arbitration can stand in the way of the respondent oblique claimant relying on section 12 bracket 5 of the 1996 Act, read with the 7th schedule thereto. Paragraph. List this matter once again. Kalke date diye dao.
I told tomorrow, Lordship, there is original side.
First original side, so very little chance of appellate side.
Thursday, then
On Purshu date diye dao. To enable Mr. Banerjee to rely on authorities in support of his submission.
Great.
You also try to find out whatever.
I will request Mr. Banerjee if you can.
Yeah, of course.
In advance,
Of course.
so that I can deal.
আমি তোমায় দিয়ে দেবো।
ঠিক মানে মানতে চাইছি না যে এত কিছু করার পরও বলবে বা ছিল বলে এখন চ্যালেঞ্জ করবে।
I think the other matter, Malad, which I was arguing on section 9 scope, that has to be de novo reheard before this bench. Where Mr. Ray was on the other side. He had finished his submissions, Malad. But
no, what we are doing in 2 or 3 matters, what we have done, matters which were substantially heard by that bench, we are releasing from this list. You have to write to the OSD, will be assigned to that bench, and Justice Rai is sitting singly. So we can assemble anytime we want to.
that's fixed on 23rd. Lordship has fixed a date for that.
On
23rd of this month.
that we can refix it, but that matter is not in today's list.
Oh, it will come up on 23rd, Lordship.
We can have it in this list before that, as to be mentioned.
But Malad, I have no issues. Both of us
No,
can.
that's fine, but it has to be done de novo, that's all.
Only difficulty is that to have my lord for a special bench is really difficult. Malad.
That will not be very difficult, given that his lordship is sitting singly. We have this.
My lord's bench, Malad, to Malad, that is the difficulty. It's better to have it, Malad.
Very well then. Let it come
Try
up,
that.
we'll see.
Great.
12,
Huh?
Award holder respondent.
Do we read correctly? 40 paper book.
40.
Look at the list.
I think four.
4 volumes.
5. I put the blame on Mr. Mondal.
For what?
So many paper books.
This
Lord.
particular matter. No, paper book has been prepared by
the respondent.
the respondent.
We have
And,
read the charges.
and the
Most importantly, I think some important documents.
sir, Lordship, I'm ready with the matter, but there has been an inadvertent oversight on my part. One of the document is missing, Your Lordship.
What do you want? Why beat around the bush? Just tell us what you want.
Might be relevant, that document, because that's a measurement subject to correction. Measurement book nahi tha.
But in a, your Lordship is in a 37 appeal.
34, that
Yes.
has, we have argued on that.
Can we go into the measurement
well.
book? Whatever
Very well,
there
we
is,
have-
is there.
We cannot reappraise evidence.
Evidence, I'm sure. Then I can start, Your Lordship, because 34 and our affidavit in reply, we have specifically relied on those documents. All the documents are there, but one document was missing. That's why I thought before starting at the outset to bring it to Your Lordship's attention.
You have a leader.
I have a leader, Mr. Ray. I'm being led by Mr. Ray, Your Lordship. But that is not the reason.
No, we understand. No, we are sure that you are absolutely ready to argue.
I'm arguing.
Would you like to argue or would you want an adjournment? This is what we are asking you.
Lordship, with adjournment, then I would like to, without any reason, I will not seek any adjournment. Then I would like to file a supplementary affidavit also regarding affidavit for
what?
This document has been missing. Letter I will disclose. With
Give
a
it
letter, I
to
will
them.
disclose.
Rely on it if you like.
That much only, Your Lordship.
When will you come back?
In a Lordship, any day after 14th.
This is astute advocacy from your behind.
Yes. That is why, Mr. Sinha, that is why I asked my learned friend to come. Because this matter also has a checkered history as the previous matter also.
When did you say? Sorry?
After 14th, any day, Your Lordship, after 14th.
After 14th.
After
Very
14th.
well. Next week? Learned advocate for the state says that some documents have inadvertently not been brought on record, which may be relevant for the purpose of disposal of the appeal. Stop. Paragraph. Leave is granted to the appellants to disclose such documents and supply copies to learned advocate on record for the respondent before the next date.
Subject to these documents being there before the trial court.
It is there. It is there. It is there.
Subject to the documents being there before the learned trial court. Which court?
Asansol Commercial Court.
District.
Stop. Paragraph as suggested, list this matter once again. Let it be there in the list on the 16th of June. Possibly before 17th it won't be called on. 16, June 16 করে দাও।
তারিখে অনির্বাণ এসে 16 তারিখে করবে তো? না করলে ওটা করবে। না করবে। ভালো।
Before Your Lordship takes the My Lord, before Your Lordship takes the original side matter, I was praying for indulgence to mention the matter which Your Lordship heard yesterday, Vidyut Lata Mahapatra, Section 9 appeal, Your Lordship has kept it at the first matter tomorrow, where Mr. Guho was arguing.
Check Guho.
Yes, Mr. Shomrat Sinmar is appearing for my client's his son was undergoing a surgery tomorrow morning. So if your Lordship please to take up instead as the first matter at 2 p.m. or next day, if it could be taken up.
We have kept it tomorrow.
As the first matter. So he will be reaching by 12:30. So if it could be either at 2 o'clock or the next day, or Thursday, if it could be.
Thursday, though, it will be appellate
So
side
if it,
again.
can it be in the second half, instead of.
2 p.m. করে দাও না। Shomrat.
Numbers 1 and 2. Before my learned friend proceeds any further, I am embarrassed to make this prayer and renew my prayer which I had made on the last occasion. There are certain pleadings which are wanting from our end. So on certain applications, Your Lordship had given us the direction on 29th of April. I'm seeking a further extension by a week's time.
কি order আছে দেখি?
If Your Lordship would be kind enough to even make it peremptory, I'm ready to file it, but
Did
a
we
week's
record a
extension.
formal order?
Yes, the formal order was there on 29th of April 2025. May I just hand over a copy? I only have one character copy.
I keep on forgetting. What do you call yourself, Miss Chatterjee or Miss Ghosh?
Nowadays, both.
Both. আমাদের ফাইলে নেই।
So the paper book is now ready, I'm told. Although I'm not favored with the paper book, but
It's been served, my lord.
yes,
We've
yes,
already-
I am not favored by my advocate on record, not your fault. But regarding the second part of the order, if Your Lordship will kindly note, let pleadings in the applications being GA numbers 2, 3, and 5 be completed in the relevant appeals. So these pleadings, at least 2 of them where I am at fault, my lord, the pleadings are not yet complete. I was humbly beseeching if Your Lordship would make it peremptory and give me a further
23rd
extension.
December.
No, 29th of April.
কি দিবে তুমি?
29th of April is the order. 29th of April is the order.
My lord, the order dated 23rd December will also be relevant because in the order dated 23rd December 2024, the pleadings for GA4 were supposed to be completed, and the other applications on the last order dated 29th April 2025, the other applications, the pleadings were supposed to be completed.
What kind of a matter is this? What
My lord, this is an appeal from Section 9 filed by my learned friend. In the Section 9 proceedings, they lost and now they have come up in appeal. Now, the main point being why there are, in fact, Your Lordship will note that there are cross objections also. Those cross objections are filed by my client on the point that there is no arbitration agreement whatsoever. So that's the preliminary point. So rest of it, whatever are there, my lord will find that the main point being that there is no arbitration agreement between the parties, and so there couldn't have been a Section 9 application in the
Oh,
first
very
place.
well, very well. We'll extend the time.
My lord-
2 weeks.
Grateful to much.
My lord, may I indicate?
What will you indicate? We are not hearing on merits.
No, no, my lord, I'm not submitting on merits, my lord.
Are you opposing the prayer for extension?
Yes, my lord, because
We are overruling that and we
very
do
well.
that.
My lord, just one request, if a short date could be given so that we
2
could move.
weeks.
My lord, because my lord, because GA4 was from December, my lord, December 2024, my lord, and I mean extensions have been prayed several times, so it is only a small request if a shorter date can be given, because because the Section 11 is also pending on the same issue, my lord. And at the same time, we'd like to
Section
file.
11 is not made to stand because of the pendency of the appeal of my learned friend.
Read order dated,
It is not
read
connecting.
order dated April 29, 2025. Next. Learned advocate for
The respondent numbers 1 and 2, my lord, in the
the
appeal.
respondent numbers 1 and 2 seeks extension of time for completion of pleadings in GA 2, 3 and 5. In GA number 2 of 2023, GA number 3 of 2024 and GA number 5 of 2025.
Also GA4, because in 4, I think I have to file a reply.
So
in
it's here for 4 of 2025 or 4.
4 of 2024.
GA 4 of 2024 and GA 5 of 2025. Eh? Stop. Such prayer is allowed peremptorily. Stop. No further time. A fortnight's time is granted for the aforesaid purpose. Stop. It is made clear that no further time will be granted. Paragraph. List the matter.
My lord, prior to that, may our affidavit in opposition be kept on record? We've already served it in December, but
Your Lordship, which opposition?
Actually, list the matter, Rage.
I appeal for the appellants in GA, in item number 2, Your
We
Lordship.
haven't received
In
a copy
GA
of
3 and
Course,
4,
sir.
I have to file my affidavit in
We haven't
opposition, Your
received.
Lordship. But the only problem is, this is a change brief. I don't have
GA3
the
board.
original of the 2 affidavits in opposition, Your Lordship. Your Lordship. I have the original for GA3, but the affidavit in opposition for GA4, I only have a copy, Your Lordship, a photocopy, Your Lordship. So the department is not allowing me to file the.
Get it reaffirmed. What stops you? Nobody stops you to get it reaffirmed.
Lord, and copy may be served. I'm told that they haven't yet caused service of these.
we've
Yes.
already served,
Serve
my lord.
copies, otherwise it will never be heard. Unless you exchange pleadings, it will never be heard. You file your affidavit.
My lord, GA3 of 2024 and GA4 of 2024, my lord.
Affidavit in opposition.
Affidavit in opposition.
Affidavit in opposition filed on behalf
Of the appellants. In item numbers 1, 2, 1 and 4, my lord.
by the appellants in APO 41 of 2024 and OCOT 4.
No, my lord, this is only in the APO. That's
Received by my client, my lord. OCOT 4 and 5, they are cross objections.
One second. You are filing affidavit in opposition in GA,
3 and GA4, my lord.
in GA3 and GA4 in connection with APO 41 of 2024, be kept with the records.
My lord, with regard to GA3 opposition, I'm told that GA3 opposition was not served. GA4 opposition has been served.
If it
Is
is
the
not
instruction.
served, it will not be heard.
Yes,
We
but
can't
we are saying that they have served, and what prevents
give
them from
them
causing
another
further
copy.
service?
We'll reserve, my lord. It's
So, once that is taken care of.
Are you filing anything today?
So far as APO 42 of 2024 is concerned, Your Lordship, I am filing the affidavit in opposition for GA3.
You are the appellant.
I am the-
Affidavit in opposition filed in GA3 of 2024 on behalf of the appellants, in APO 42 of 2024, be kept with the records. Paragraph lists the matter, fortnight hence, a fortnight hence, retaining their positions.
Grateful.
You bring back whatever you want to file, we'll allow you to file.
my lord, I'm led by
Just give them advance copies.
my lord, I'm led by Mr. S.N. Mukherjee in this matter. My lord, could it be on the 26th?
26.
Grateful, my lord.
Fortnight na kore, as suggested by learned advocate for the appellants in APO 41 of 2024 comma, list these matters once again on
26.
26.
Grateful, my lord.
Item number 6 and 7.
You will have to argue afresh before this bench or get it assigned before that bench. It's your choice. Because I remember we had heard this matter, commercial, non-commercial.
We'll do it afresh, man.
ওদের cross objection.
हाँ ठीक है premises to नहीं चाहिए
Original act, original act. चले गए थे जब actually 2000
plain tag होता है
plain to that's one. Next is the
हाँ ठीक है well, a short point in this appeal is whether an eviction suit under the provisions of the West Bengal Premises Tenancy Act, which has been filed before this court, can fall within the purview of commercial dispute so as to be heard by the commercial division of this court. This is the short point. Well, by the order under appeal, the plaint has been rejected or returned on the ground that the ordinary original site does not have it's not the proper forum, and the proper forum is the commercial division of this court. This is the short point. Now, my lord, before I come to the judgment, my lord, the judgment impugned, kindly have a look at the plaint once, because, my lord, rejection of plaint, it will go by the averments made by the made in the plaint. Kindly come to page 78 of the state petition. Lordships have that one. Plaint, I'll only trouble your lordship from paragraph 4. Sorry, my lord, yes, paragraph 4. My lord, after, my lord, the plaintiff's title has been traced and the suit property has been described. Para 4, plaintiffs, because, my lord, this is a suit under section 2G of the Premises Tenancy Act, West Bengal Premises Tenancy Act. My lord, lordships are aware, my lord, section 2G, the definition of tenant, my lord, pursuant to the
5 years.
97 Act, a new feature was incorporated that, my lord, the earlier 56 Act, which, my lord, made almost tenancy, my lord, generation after generation, here a cap was fixed that after 5 years, you will not, the heirs will not be, heirs who are ordinarily residing will no longer fall under the definition of tenant. This is the unique feature of 2G. So, my lord, para 4, plaintiff states after the death of Sotyaranjan Kundu on 24th September, the tenancy was transferred in the name of his widow, Durgarani Kundu, and thus Durgarani Kundu became the monthly tenant of the suit property at a rental of 2310 payable according to English calendar month. Said tenancy at all material time was governed by the provisions of West Bengal Premises Tenancy Act. Durgarani Kundu, so my lord, para 4 shows that Durgarani Kundu became the original tenant, if I may use the expression, because, my lord, the landlord had accepted. Durgarani Kundu expired on 27th May 2015, leaving her son, namely Probir Kundu, as the only legal heir and representative. Probir Kundu was ordinarily living with said Durgarani Kundu and up to her death as a member of her family and was dependent on her, and Probir Kundu, being the son of the original tenant, was a deemed tenant of the suit property for a period of 5 years from the death of the original tenant. Probir Kundu also has expired. So, my lord, this class of plaint falls in a category which is much better than, because even, my lord, the original who could have claimed to be an original tenant, my lord, 5 years, at least for 5 years, even he has also expired. Plaintiff states for a period of more than 6 years has expired from the death of said Durgarani Kundu. Plaintiff states due to the death of the original tenant Durgarani Kundu and upon expiry of the period of 5 years from the date of death of the original tenant, the tenancy has come to an end. The defendant being the daughter-in-law so and so. That I need not trouble your lordship with the other paragraphs. This is in essence the cause of action. 1 minute. Yes. My lord, my learned junior points out that I should show your lordship, my lord, page 80, para 10 of the plaint. There is also an usual suit of declaration and permanent injunction which has been pleaded over here. That has been dismissed. But, my lord, for rejection of plaint, my lord, all that we have to see is, my lord, now lordship will come to page 83, internal page 6 of the plaint. These are the reliefs claimed. Decree for eviction, recovery of cash possession, and, my lord, 11 lakhs and odd as mean profit and rent, and further 10,000 per day, my lord. This is mean profit pleading is at para 70. Yes. My lord, my first submission is that the suit is squarely covered under the Premises Tenancy Act. My lord, lordship would recall, my lord, earlier, my lord, when 1997 legislation was first promulgated, my lord, it was only the rent controller which could try the suits. Then, my lord, it was amended, and, my lord, certain designated courts were, my lord, considered, and that was done. And then, my lord, subsequently now, my lord, depending on jurisdiction, even, my lord, this High Court in its original side, if the otherwise pecuniary limit permits, my lord, the West Bengal Premises Tenancy Act suits can be tried. Now, if lordship comes to the order under appeal, or the judgment under appeal, but I'll read the order, the judgment from the memorandum of appeal. Lord, the judgment, my lord, I shall indicate to your lordship. It has taken, my lord, the last pronouncement of the Supreme Court in a literal sense and has gone by the user of the premises. And the learned judge has held that if the property is being used as a commercial property, we look no further. It goes to the commercial division.
A commercial courts act though.
Lord, if lordship takes, my lord, section 2.
There has to be an agreement relating to immovable property.
Agreement relating to immovable property, my lord, section 2C, clause 7. Agreements relating to immovable property used exclusively in trade or commerce. My lord, my first submission is that, my lord, once it's falling under the purview of the West Bengal Premises Tenancy Act, my lord, of course, my lord, every landlord-tenant relationship is an agreement. But here, my lord, it's a statutory agreement and it is not a bilateral agreement as such. Because, my lord, if it is covered under the Premises Tenancy Act, the terms of the agreement will not determine when the tenant will leave and all that. The statutory protection, because it's less than 6,000 or 10,000, it should be less than 10,000 since it's a commercial property. So, my lord, agreement here is overtaken or overridden by the statute. That's my first submission. Second, My lord, the statute provides that suits under the West Bengal Premises Tenancy Act can only be tried by the designated courts. And now if Lordship takes the judgment, the user of the premises, my lord, is in relation to the definition of this act. But the user alone will not confer jurisdiction in the sense that it is not, my lord, Premises Tenancy Act is an independent act of its own. If it is covered, on one hand, you cannot say I am enjoying the benefits of statutory protection under the Premises Tenancy Act because I have to go by the regards. This is a case of, my lord, 2G. But, my lord, I go by the regards of Premises Tenancy Act. Otherwise, if, my lord, let us say the agreement says after 5 years you will go out. I can't because it's protected under the Premises Tenancy Act. Now, kindly see.
Mr. Chaudhary, I'm just trying to understand. Where is there an agreement in this case? Is there an agreement relating to the suit premises between the plaintiff and defendant?
No.
After that, trade and commerce comes.
No agreement.
So if that is so,
No.
7 will not apply at all.
That is the thing. There is no agreement. It's a my lord, agreement means in the sense, my lord, oral agreement of, my lord, give and take of last paid rent, my lord, Lordship has seen 2000 and odd. That is with the predecessor who has also died. My lord, every tenancy, landlord tenancy, my lord, there is an agreement in the sense, my lord, oral agreement. Let us put it this way. But Commercial Court Act, my lord, it proceeds on an agreement, my lord, though it's not specified, but it is, my lord, it has to be an agreement in writing where commercial terms are delineated. Here, my lord, Lordship will not find any agreement in writing. And secondly, my lord, now Lordship takes the judgment once. Kindly comes to the judgment, my lord.
In this respect, by just one point, I just want to intervene. There is an agreement, but since this point did not arise before the learned trial judge, so that we could not produce it. The landlord and the tenant.
Plaintiff and the defendant.
We have that agreement.
Copy they'll consider.
No, father-in-law, no. Kobir Kumar Kundu is the husband of the.
Yes.
That kindly takes the judgment.
Yes.
We can file it by way of an supplementary affidavit.
Disputing the authenticity of it.
My lord, rejection of plaint will go by, my lord, the averments made in the plaint. Assuming, my lord, I don't dispute it, my learned friend is producing it. Let us assume it is there. No, it is there. It is again with the predecessor, maybe 30, 40 years back, but that is not because it is.
Husband, Probir, husband of this defendant.
No, my lord, I don't think, my lord.
And also Durga Rani Kundu. Another one.
120 square feet
1998
এটা কোনটা
এটা আরেকটা টেনেন্সি আছে
ও
এটা দেখুন না এটা আরেকটা
my learned junior points out that this is in respect of another tenancy, not
120 square feet.
120 square feet. Not this one. Perhaps my learned friend was.
There are two shop rooms.
Yes, so this is not the suit property.
It is one of the part of the shop rooms.
We'll come to that, my lord, because I have been non-suited not on this ground. I have been non-suited because of another ground. The defendant has filed the present application praying for rejection. My lord, para 2 is very important. The contention raised by the defendant in the present application is that the suit filed by the plaintiff is a commercial suit, but has filed in the non-commercial division. The defendant is running business in the suit premises. It is also the contention of the defendant that the suit property is for non-residential purpose, and under the provisions of 2G of the West Bengal Premises Tenancy Act, protection is granted only for residential purpose. Well, this point is no longer res integra. It is well settled now, my lord, post, my lord, the judgment of our division bench that 2G covers both residential and non-residential so far as that 5-year period is concerned. And that is also not their contention as well. It has been taken, but it is there. It is also the contention that the husband defendant, namely Probir Kumar Kundu, left behind his wife, the defendant herein, one son and one daughter, but the plaintiff has not made all legal heirs of Probir Kundu as defendants. On 28th April 1993, the husband of the plaintiff and plaintiffs jointly purchased. My lord, I need not trouble your lordship. Kindly come to page 3, para 4. Mr. Dotto, learned advocate representing the plaintiff, submits one Shottoranjan Kundu was the monthly tenant with respect to the suit property. Shottoranjan Kundu died on 24th September 1998, and after his death, the tenancy was transferred in the name of his wife, Durga Rani Kundu. Durga Rani Kundu died on 27th May 2015, leaving behind a son, namely Probir Kundu, as the only legal heir and representative. Mr. Dotto submits that due to the health of the original tenant, Durga Rani Kundu due to the death of the original tenant, Durga Rani Kundu, upon expiry of the period of 5 years from the date of death of the original tenant, the tenancy has come to an end. So, my lord, case made out in the plaint, the case submitted is that of 2G. Now, my lord, prior to trial, assuming what my learned friend now says, if they bring that fact in written statement, it becomes a triable issue. It will be a triable. That is trial. Question is where such trial will be held. Because I have been ousted at the threshold. Now the reason for that is, kindly come to, well, at page 4, I want to place on record my learned friend's submission. Now, well, what my learned friend says today and what is recorded here is perhaps, well, this was not the submission even before the learned court, first court. Kindly see, well, at para 8. Per contra, Mr. Mukherjee, learned advocate representing the defendant, submits sometime in the year 1952, the father-in-law of the defendant, namely Shottoranjan Kundu, was inducted as tenant in respect of one shop, so and so. Kindly note the area. Area 160 square feet. Together with adjacent godown measuring so and so, along with one common bath. He submits the father-in-law of the defendant was carrying on business of so and so, Joshoda store, so and so. Then, para 9, 5th line. After the death of Shottoranjan Kundu, the license was transferred in the name of his wife Durga Rani Kundu and has started carrying on her business as sole proprietor. Mother-in-law defendant also started paying monthly rent, so and so. Then para 10. After death of mother-in-law on 27 May, the husband started running business in the premises. Trade license in Joshoda store was transferred in the name of the husband. He submits husband. So, my lord, there is no agreement, my lord, vis-a-vis, my lord, what my learned friend now shows. That is not even the case made out before the learned judge. That is why I was taken slightly by surprise. But be that as it may, my lord, assuming the document can be said to be correct, it is 120 square feet. The subject matter of the suit property is another shop, which is 160 square feet. And this is the submission made by my learned friend in the first court. Mr. Mukherjee's submission is recorded. Now, my lord, after the submissions, kindly straight away come to, my lord, internal page 6, para 13, 2G has been quoted. Then, my lord, internal page 7, paragraph 14, my lord, Nasima Naki has been quoted. My lord, Nasima Naki is the case where, my lord, this became applicable even for commercial properties were also included within the ambit of 2G. The ratio of Nasima Naki, lordship will find at internal page 9. Kindly come to para 23, right at the top, from Nasima Naki, which is quoted. Nasima Naki. This was the division bench. Nasima Naki is the division bench order, division bench presided by Justice Shonji Banerjee, and this division bench order was challenged and approved by the Supreme Court by the Chief Justice's bench then, or Justice Chandrachud's bench. I don't recall whether he had become the Chief Justice by then or not. The two principal legal questions are thus answered as follows. The spouse of a deceased tenant is not entitled to protection from eviction in respect of premises let out for non-residential purpose beyond the period of 5 years from the date of death of the original tenant, if such original tenant died after coming into force of the Act of 1997. The spouse of a deceased original tenant does not have any right to have a fresh agreement executed in such spouse's favor in respect of any premises let out for non-residential purpose if the decree holder landlord wishes to let out the premises afresh after obtaining so on. Then, my lord, reference is given to the Supreme Court order in Nasima Naki. I need not trouble your lordship because, my lord, the issue involved is not this. Kindly straight away come to internal page 11. Para 16. Durga Rani Kundu, being the original tenant, died on 27th May 2015. Husband of the defendant, being the son of the deceased Durga Rani Kundu, continued with the tenancy for more than 5 years after the death of Durga Rani Kundu. Now the husband of the defendant also expired on 2nd February 2018 and the defendant is continuing with the tenancy. Thus, the defendant is not entitled to benefit of 2G of the Act. Then, my lord, straight away, no further discussion on the Premises Tenancy Act. Commercial dispute is referred to. A dispute arising out of and clause 7 of section 21C is quoted. Agreements relating to immovable property used exclusively in trade or commerce. And then, my lord, the main fulcrum of the learned judge's findings, my lord, appears to be the ratio of the decision of Ambalal Sarabhai. This is, my lord, the last case or the most prominent case decided by the Supreme Court. Ambalal Sarabhai has been quoted in paragraph 18. If I may just read para 37 of Ambalal Sarabhai, which has been quoted at internal page 12 itself. Para 37, because that's the ratio of Ambalal Sarabhai. A dispute relating to immovable property per se may not be a commercial dispute, but it becomes a commercial dispute if it falls under subclause 7 of section 21C of the Act. That is, the agreements relating to immovable property used exclusively in trade or commerce. The words used exclusively in trade or commerce are to be interpreted purposefully. The word used denotes actually used, and it cannot be either ready for use or likely to be used or to be used. It should be actually used. Such a wide interpretation would defeat the objects of the Act and fast-tracking procedure discussed above. The plaintiff in paragraph 3 of the plaint mentioned that originally one Shottoranjan Kundu, since deceased, was monthly tenant in respect of one godown measuring about 264 square feet, wooden structure with tin shed, so and so, 3 for so and so, suit property. In the affidavit in opposition of the present application, it is the specific case of the defendant that since inception of the tenancy, the suit premises is being used for the purpose of business of ready-made garments under the name and style of Joshoda Stores. Original tenant has obtained trade license from Kolkata Municipal Corporation for the purpose of business of ready-made garments, and the said trade license is extended from time to time, and at present the trade license is in the name of the defendant. The plaintiff has not denied that the defendant is running business in the said premises. We are not disputing, my lord, so far as the user is concerned. Plaintiff also proceeds on that. The fact that it is having commercial usage, that is not a dispute. Issue is, if it is having commercial usage but covered under the Premises Tenancy Act, then also, my lord, commercial division under the Commercial Courts Act. This is the small issue that we are concerned with. Para 22. Considering the above, this court finds since inception, the defendant is using the said premises for the purpose of ready-made garments under the name and style of Joshoda Stores, and the Kolkata Municipal Corporation has also issued trade license. Case is squarely covered under 21C7 of the Commercial Courts Act 2015. In view of the above, the plaintiff is returned. So, my lord, the learned judge is proceeding only on the basis of user. And then, my lord, once the user is ascertained its commercial property, look no further, only the commercial usage, if I may say so. Now, my lord, kindly takes the provision of the Premises Tenancy Act.
ওরাও মানছে জুডিকশন আছে ক্রস অবজেকশন উপর অ্যাপিল করেছে তো কি হচ্ছে অ্যাডজুডিকেশন ক্রস অবজেকশন তিনটে গ্রাউন্ড অ্যাডজুডিকেশন কোন কিসের জন্য করেছেন কি অ্যাপ্লাই করে না
না না জুরিসডিকশনটা মেনে নিয়েছে
দ্যাটস ইমপ্লাইড অ্যাকসেপ্টেবল জুরিসডিকশন
আচ্ছা এটা বলছি The Lordship has already seen, my lord, the definition, my lord, section 2G. My lord, kindly comes to section 6. Lordship has seen, my lord, 5 years and all that. That is quoted also by the learned first court. Kindly see, my lord, the agreement, my lord, my first submission is that once a case comes under the West Bengal Premises Tenancy Act, the agreement is already superseded in the sense that, my lord, the act takes over, assuming for a moment there is an agreement. My lord, once it is covered or it is protected under Premises Tenancy Act, my lord, it is no longer a dispute which is arising out of the agreement. My lord, let us take the best possible case which they may have. Let us say there is an agreement. Agreement says you will leave after 5 years. Unregistered agreement, 5 years tenancy, this, that. Agreement, it's a commercial property. Terms are there. Less than 10,000, protected by the Tenancy Act. Can I evict the tenant after 5 years? Answer is in the negative because it is protected here and I read section 6. Notwithstanding anything to the contrary contained in any other law for the time being in force or in any contract. So it's a non-obstante clause which is override, assuming there is an agreement. Well, my first case is there is no agreement here. Now, assuming there is any agreement or they can produce something disputed, undisputed, we'll come to that later. It is inconsequential because it is starting with a non-obstante provision, notwithstanding anything contained to the contrary, either in any law or in any contract. No order or decree for the recovery or possession of any premises shall be made by the civil judge having jurisdiction in favor of landlord against the tenant, except on a suit being instituted by such landlord on one or more of the following grounds, and well, these grounds are there. I am not troubling your lordship on this. Well, my second submission is the plaint case is proceeding that he is a trespasser in law by virtue of the statute. Once a case, a plaint is falling under the aegis of section 2G.
This is for intellectual discussion. This protection under section 6, the original tenant will have no problem. But the deemed tenant, his successor, son or widow, or wife of predeceased son, ordinarily living with the original tenant, he or she will have the protection forever. No, only 5 years.
That is, yes. So that is why, my lord, two categories have been created. My lord, there can only be two situations. My lord, this is apropos, my lord, the issue that we are concerned. Either you say I am asserting my right, if you say it's a commercial dispute or it is falling under 2(1)(c) clause 7, then, my lord, there are two things that come into the picture. Firstly, it's an agreement. There is an agreement between the parties which is governing the relationship. And secondly, it is a dispute arising out of that agreement, which is the subject matter of the suit. Now, my lord, the plaint case, the plaint has to be taken as it is for the purpose of a demurrer proceeding under Order 7, Rule 10 or Rule 11, whatever way you look at it. The plaint is not proceeding on any dispute pursuant to an agreement, either statutory or bilateral between the parties. The plaint is proceeding on the premise that after the death of the original tenant, 5 years have passed and the defendant doesn't have any semblance of right, either statutory or contractual or otherwise. Now, if that is so, my first submission is that the plain reading of the plaint shows that it is squarely under 2G, and once it is under 2G, it cannot be, my lord, either a bilateral contractual agreement, because once you say, my lord, I am covered under premises tenancy, let us assume best possible case, I am a tenant under Premises Tenancy Act. Because, my lord, their cross objection also, they have asserted some rights that no, it's an incorrect adjudication of that. That's on merits. I am not on that. But, my lord, once you fall under the purview of the Premises Tenancy Act, the question of a commercial dispute within the meaning of Section 2(1)(c), in my respectful submission, my lord, does not arise at all. It cannot arise.
Why, Mr. Chaudhary? What the Commercial Disputes Act really, in essence, prescribes is a separate division of the High Court for speedy disposal of high-value cases or disputes which are perceived to be commercial disputes, as defined in the Act. There may be a written agreement of tenancy in a given case in respect of a property used exclusively for trade and commerce by the tenant.
Lordship.
And a situation like the present one may still arise,
Lordship.
that the deemed or legal heir has outlived the 5 years.
No, my lord,
It is
anyway,
only a
lordship
question-
completes my lord's thought.
Only a question of the forum.
No, my lord, I just formulate it this way. I understand what is falling from your lordship. My lord, I'll put,
Substantive law will not change.
I bow down. That is where, my lord, that is the basis of my submission. Lord, let us take the example which fell from my lord. There is a document in writing delineating the commercial terms between the parties. No dispute, it's a commercial property. It is usage is also commercial. Once, my lord, because of the rate of rent, it falls within the purview of the Premises Tenancy Act.
Protection.
Protection comes in. Then, my lord, once this protection comes in, the forum which is considered under this statute, that is the civil court, the ordinary civil court, that forum and the grounds on which eviction can be effected, that gets triggered.
Is commercial court not a civil court?
It's a separate class. I'll come to that. I'll come to the provision of this act. It's a separate class. Because, my lord, lordship has seen, my lord, may I read section 6, my lord, to answer my lord's query? Notwithstanding anything to the contrary contained in any other law for the time being in force, or in any contract, no order or decree for the recovery or possession of any premises shall be made by the civil judge having jurisdiction. By the civil judge having jurisdiction, and later, my lord, I'll show notification, High Court was also in favor of landlord to the tenant having one or more grounds. So, my lord, earlier to this civil judge, my lord, rent controller was there. So, my lord, section 6 is having twofold effect. It is overriding provisions of other law and also provisions of contract. Now, my lord, once this happens, assuming, my lord, I am a tenant who has an agreement. the contract is getting overridden by the provision of statute because the relationship is no longer being governed on the basis of a contract but by statute. All landlord tenants are, my lord, there is a contract. Question is whether it is a bi-party contract or, my lord, a contract, deemed contract, which is assumed by a statute. This is my first submission. My second submission is, my lordship has seen the definition of 2G. So if you are not a tenant, under 2G, you are a trespasser. Now, if I file a suit against a trespasser, do I file it in a commercial court? Because, my lord, I'll argue otherwise. Once I file a suit against trespasser in a commercial court, I admit that there is an agreement between the parties.
I agree with you. If you file a suit on the basis that the defendant is in illegal occupation, being a trespasser, no problem. But I was trying to visualize the situation. This is again intellectual exercise.
No, my lord, I must be candid, my lord. Law is not settled, and my lord, lordship sitting in the division bench will settle the law. In fact, my lord, it will perhaps be more convenient, assuming I lose in this matter. Lordship's hold, my learned friend's contentions are right, and the lordship upholds the judgment of the. It becomes more convenient in this sense, my lord. Under Commercial Courts Act, I get the benefit of Order 13A. I'll simply file an application under Order 13A, my lord, and I get a summary decree because 2G suits we don't require trial. I'll be very candid, my lord. That was my first impression also.
Order 13A?
Order 13A of the Code of Civil Procedure as amended. My lord, the Chapter 13A provisions which we have in our original side rules, now, my lord, by virtue of the Commercial Courts Act, whatever is falling within the purview of the commercial division, there is a special amendment to the Code of Civil Procedure, and a summary procedure has been introduced by way of affidavit evidence and exchange of affidavit evidence. Well, it is akin to, let's say, our Chapter 13. Akin to that. In fact, parameteria, not identical perhaps, but parameteria.
Yes, we have followed. In this case, you file the suit on the basis that the defendant is a trespasser.
Well, assume, my lord, I kindly take the plaint once again and kindly see, my lord, if I say commercial division, my lord, towards the end, I'll have to plead the dispute between the parties is of a commercial nature and falls within the definition or comes within the purview of Section 2. I admit that there is an agreement. When there is none, suppose, my lord, I file the plaint in the commercial division. My lord, my other side will come and say, my lord, I am not restricting to my learned friend. Anybody will come and say, the very fact you are saying you are filing it in the commercial division, that presupposes there is an agreement between me. I am not an outright trespasser, and that. And 2G is a case of an outright trespasser. Once the statute, because, my lord, your right is only limited to that 5 years, and you become an outright trespasser. It is not that when you were there, you were proper and all that. It's an outright trespasser. It's not a tenant at sufferance, as we call it. My lord, as in cases where after lease expires, my lord, we call the defendant who's still occupying the suit property tenant in sufferance. But, my lord, 2G, these principles do not come. You are qualifying as an outright trespasser. Now, kindly visualize the dichotomy, my lord. On one hand, I am filing the suit against an outright trespasser. And, my lord, I have to go to a commercial division, which presupposes there is an agreement between us in respect of a commercial property. But I become akin to Kalidas. I cut the branch on which I am sitting. So this is, my lord, the inherent fallacy in my respectful submission. And, my lord, the learned judge has not considered this aspect at all, that the primary suit in the plaint or the plaint as it is couched, my lord, it is squarely for 2G. On merits, they may have a lot to say. I am not on that. Whether, my lord, who became tenant, not tenant, that we will, my lord, we'll think of the bridge when we come to the river. But my lord, I cannot be when my case on the plaint and for a demurrer application, the averments made in the plaint are true and correct. You look, it about you. For the averments made in the plaint being deemed to be true and correct, my lord, I cannot, my lord, that is why I took your lordship through the averments of the plaint first. My lord, on the reading or the averments made in the plaint, my lord, till written statement comes, my lord, I cannot be non-suited or the plaint cannot be rejected or returned, my lord, on the averments made there, saying it's a commercial dispute. Then you are really, my lord, the court is making an agreement for a defendant where there is none. Because, my lord, kindly see the definition of commercial dispute once again, section 2.
Ambalal may be not of.
Ambalal was in a different context.
Correct. Purposeful interpretation, it has to
My
be
lord, that
actual.
was, my lord, we were considering Ambalal, my lord, all those issues were there, section 12A, that leave, whether leave, it doesn't contemplate a leave.
Very well. Any authority you want to cite?
No, my lord, unfortunately, my lord, on this aspect, my lord, there is at least subject to what my learned friend may show, my lord, it's an absolutely uncharted territory, because, my lord, it has, on the Premises Tenancy Act, my lord, there is no authority that I could, my lord. All the authorities are, my lord, Ambalal, following Ambalal, whether, my lord, the agreement is this way or that way. But really, my lord, the aspect of Premises Tenancy Act has not been gone into, my lord. At least I could not lay my hands on. But I'll just conclude in a minute or two. Kindly have a look at section 2 once again. ওইটাই দেখাচ্ছে কমার্শিয়াল ডিসপিউটেড এটা
কমার্শিয়াল এগ্রিমেন্টটা হচ্ছে প্রি কন্ডিশন।
Well, it kindly takes commercial dispute under section 2, 1C. Commercial dispute means a dispute arising out of. So the dispute should arise out of an agreement. Well, oral or otherwise, we'll come to that later. Well, here the dispute is arising out of not an agreement, but because of the statutory provision which is making them trespasser, and there cannot be any agreement. So once, my lord, there is no agreement, because, my lord, the learned judge has restricted himself only to the user of the premises.
This is where I am not very clear. That you said there cannot be any agreement. Even if there is any agreement.
My lord, I bow down. My lord, I am looking at it in this way. The reason
your cause of action arises not in relation to any agreement,
correct,
even if there be any.
Correct. I am on a better footing. Assuming, my lord, lordship is having doubt, my lord, I had couched my case in a sense that assuming I had an agreement. But, my lord, I am not required to go into that. I am on a better footing because, my lord, firstly, there is no agreement because 2G is coming in because, my lord, tenant or not, you are no longer under the definition of tenant, protected or unprotected. You are a trespasser outright. Once that happens, my lord, it cannot be a dispute. My lord, it will not fall within the first limb of 2C so as to percolate down to clause 7. To come to clause 7, you will have to first cross the hurdle of the first definitive part of commercial dispute. That is, it has to be a dispute arising out of, then it will percolate down to 1, 2, 3, 4, then we come to 7, agreements relating to immovable property used exclusively in trade or commerce. So it will not percolate down to any of the clauses because you get stuck or the door is shut at the first instance itself. That you are a trespasser under 2G if you have no contractual relationship of any nature whatsoever, either statutory or otherwise. Now, he may have in the written statement, he can come up and say, no, I have this contract, I have that contract, whether fraudulent or not fraudulent, whether it relates to the property, that's a secondary issue. But on the plaint case, that is why I showed your lordship the plaint. The plaint as it is formulated, my lord, in my respectful submission, my lord, this court has the jurisdiction and it should not be sent to the commercial division. My lord, those are my respectful.
My application was under Order 7, Rule 11. So I have to restrict my submission to whatever is there in the plaint. I have made an application under Order 7, Rule 11, elaborating that whatever is in the plaint, from the plain reading of the plaint, the suit cannot proceed and the plaint should be rejected so that proper steps may be taken. And a plain reading of the plaint does not give rise to any cause of action for the plaintiff to file the present suit for eviction of the defendant. This is the settled principles of law also under Order 7, Rule 11. I cannot take out a defense.
Mr. Mukherjee, tell us one thing. This point of commercial dispute, was it taken by you or by the learned judge himself?
No, the learned judge by himself.
By himself. Yes, carry on.
When this was taken, we argued, but this was taken. It was taken by himself, and at that point of time, that matter was argued by Mr. Datta and myself also.
Para 18, a pleading is there. I was not there in the court, first court, but para 18, my learned junior points out, para 18 of their application, a pleading is there that it's an exclusive commercial property.
Oh, it's there.
The commercial property,
No,
that
that's
is for separate reason. We made an amendment in our Order 7, Rule 11 application. Now, Lord, if your Lordship kindly looks at the plaint for 3 days. The plaint starts from page 78.
প্লেনটা দেখছিলাম একটু আগে এখানে। Yes.
Plaint starts from page 78, Lord.
Yes.
By 2 separate registered deed of conveyance, both dated 28 April 1993, the plaintiff above named along with her husband, late Govinda Prasad De, became the joint and absolute owner of the property situated at municipal premises number 103B, Vidhan Saroni, PS Shampukur, Kolkata, Kolkata 4. On or about 5th June 2008, said Govinda Prasad De died, intestate, leaving behind plaintiff as his legal heir and representative by virtue of inheritance and succession. The interest of Govinda Prasad De in the said property has devolved upon the plaintiff, and the plaintiff thus became the sole and absolute owner and landlord of the entire property. Originally, one Satyaranjan Kundu, since deceased, was the monthly tenant in respect of one godown measuring about 260 square feet, 264 square feet, and one wooden structure godown with tin shed measuring 348 square feet situated on the ground floor of the said property, more particularly described in Schedule A and B hereunder written, and is hereinafter referred to as the suit property. So, suit property consists of 2 parts, Schedule A and Schedule B, and once both are, they say, either godown measuring 264 square feet and 348 square feet. This is the suit property, Lord. Now, Satyaranjan Kundu was the original landlord. He died on 24th of September 1998.
Satyaranjan Kundu was the original landlord.
Original tenant, Lord. He died on 24th of September 1998.
This date is very important, my lord, because he died when the Act of 1997 was not in force. It came into force in the year 2001. And at that point of time, the Act of 1956 was in force, my lord.
Mr. Mukherjee, please don't argue on your defense against eviction. We are only on whether this is.
2G applies, my lord.
No.
They say, my lord.
No. The issue is whether this is a commercial dispute or not.
Two issues, my lord. One issue has been held against me, my lord, as well.
We have seen that. But he has been non-suited. That issue has been decided in his favor. That will arise at the trial, before whichever forum.
But at the same time, my lord, this 2G issue has to be answered, my lord.
Yeah.
If
Yes, you have a cross objection, don't you?
I have a cross objection, my lord, because unless this 2G is answered, my lord, then I am gone, my lord.
Very well.
This will be settled for once and for all. And this 2G, as my learned friend has argued, if this 2G is answered against me, my lord, then I am a trespasser. If I am a trespasser, then it will not go to the commercial courts under any circumstance.
You agree to that.
I do agree.
I think, my lord, then my lordship can record this, and my lord, in trial it will be a preliminary issue. After evidence, this has to be decided to. Or my lord, chapter 13A or order 13A, whichever chapter, whatever it is.
But at the same time, 2G is there, my lord. That has to be answered.
Because my learned
that
friend
has
is
gone against me.
Learned friend has conceded, well, 2G, whether it's on merit.
Mr. Mukherjee, we will say that that portion will not be relied upon at the trial. We'll clarify that. The plaint is based on 2G. Today, one has to look only at the plaint. We appreciate your worry that unless we say something about the learned judge's finding on the point of 2G, that will remain staring at you forever. So we'll make it clear that this will be a preliminary issue. But how can it be a preliminary issue, Mr. Chaudhary? Cannot be a preliminary issue.
It has been already answered.
Well, that is all the more, my lord, that is all the more stark that after holding this, my lord, I am non-suited only on the ground of jurisdiction. The case is so much clear.
Both are interlinked, lord. Both are interlinked.
In fact, yes, very well, you argued.
Now, and why I'm arguing this, Lord, because in this point, the Honorable Supreme Court has already delivered a judgment, Lord, and this point has been decided. Now, Lord, originally one Satyaranjan Kundu, since deceased, was the original monthly tenant, and he died on 24th September 1998. The tenancy was transferred in the name of his widow, Durgarani Kundu, and thus said Durgarani Kundu became the monthly tenant in the suit property. This is their case, my lord. Now, Durgarani Kundu expired. Your lordship will find in paragraph 5, my lord, on 27th May 2015. This is the cause of action, lord. From 2015, 5 years starts. And after so it ends on 26th of May 2020, my lord. After that, whoever is there becomes a trespasser, including his son. Now, unfortunately, his son dies in the year 2018. Next page, my lord. His son dies, my lord, Probir Kundu. I'm just giving the dates, my lord.
In fact, would the defendant be entitled to any protection at all? Because 2G mentions only widow, son, and wife of a predeceased son.
Since this is a non-residential premises.
Residential and non-residential, now revision bench has said same.
If it is same, Lord, then they will get the protection, Lord.
Achha, very
Why
good.
I'm saying that this, Lord? Because Probir Kundu also is a legal heir, and he was staying with with his father,
With his mother.
with his mother and father.
Does he become the original tenant?
He becomes our original tenant. He also becomes original tenant. Lord, kindly looks at the judgment of the Honorable Supreme Court in this regard, Lord. No, আরেকটা copy.
না, বলছি মা মারা যেহেতু ছিল original tenant।
The reference is দিচ্ছি।
ও তো জীবনের ফটো তুমি ইনভিট করতে পারো।
And Lord,
এবার বলবে যে
my learned friend is
original tenant।
He's citing the Rajesh Mitra judgment. My lord, I had argued this matter in
my
the
learned
Supreme
friend
Court,
argued.
but it's on a different point. I lost there, but this is on a different point. Not
I'm showing, Lord, this is not a
a
different
review
point.
is pending, but it's on a different point. But here, in this case, the Supreme Court, my lord, upheld a single judge view of Justice Dipankar Datta, saying that, my lord, that a vested right had accrued. My lord, if the death had happened, my lord, prior to the promulgation of the act, a vested right under that had accrued, so therefore it cannot be taken away by that. Then our division bench, my lord, had disagreed and overturned that, and that was holding the field. And then, my lord, this judgment came where, my lord, now the last 25 years law has been sort of unsettled. But we are not concerned over here because, my lord, in paragraph 4 of the plaint, the transfer of the tenancy is admitted, and, my lord, Durgarani Kundu died on 27th May 2015. So this judgment
The original tenant, Lord, was according to them was Satyaranjan Kundu, Lord.
Yes.
Can't go back.
So Satyaranjan Kundu died in the year 1998.
Only for the benefit of your learned friends, roughly how long will you take?
And, another 15, 20 minutes.
20 minutes. Released. 20 minutes necessarily means at least half an hour.
Because I'll be placing the judgment referred to by my learned friend, of Justice Dipankar Datta also. That is also important. Gautam De versus Josna Chatterjee. Lord, kindly come to page 12, Lord. Internal page 12 of the judgment, Lord.
Yes.
On behalf of the appellant, we have heard the learned counsel Ms. Rashi Bansal, who relies on the decision of the learned single judge of Calcutta High Court, Gautam De versus Josna Chatterjee. In the above cited case, the original tenant had died prior to enforcement of the 1997 Act. He was survived by his daughter and husband, Gautam De. Subsequently, the daughter of the original tenant also died in the year 2011, after which the respondent landlord filed a suit for eviction against Gautam, which was decreed. By virtue of Section 2H of 1956 Act, it was held that a vested right had accrued in favor of the daughter of the original tenant, which could not be abrogated by the enforcement of 1997 Act. It was further held that if Section 2G of the 1997 Act was interpreted literally, it would mean all inherited tenancy under 1956 Act would expire on 9/7/2006, 5 years after the coming into force of 1997 Act. This is a position which cannot be tenable in law. According to the learned single judge in the above case, it was held that the phrase "or from the date of coming into force of the Act, whichever is later," was wrongly drafted by the legislature, and it is in fact redundant. That is what was said. Even then it was quoted, my lord. Even otherwise, I am of the further view that portion of Section 2G as extracted in the proceeding paragraph starting or ending with latter, which Mr. Bhattacharya laid emphasis, if read literally would produce absurd result, and therefore the provision must be so read so as to make it meaningful. Law is well settled that in exceptional circumstances it would be proper for court to depart from the literal rule, and also rule of the interpretation would be adopted that is just reasonable and sensible and does not offend the sense of justice. In the context, one may possibly conceive either of three inevitable situations: death of a tenant, that is before July 10th, 2001, after July 10th, 2001, and on July 10th, 2001. Regarding situation that is death of a tenant before July 10th, 2001, and the case with which I am concerned, Sunil died on 4th May 1998, just like our case, my lord. Undoubtedly, it was the Act of 1956 Act that was in force, and had a tenant governed by the provisions of 1956 Act of 1956 died on 9th July 2001, or even provisions of that date, the tenancy would be governed by that act, meaning thereby that the tenancy being heritable, the heirs would be justified in claiming tenancy right, subject to fulfillment of the residence requirement of Section 2H of the Act of 1956. But unfettered by the two conditions newly inserted and stipulation of 5 years in Section 2G of the Act of 1997, law appears to be settled that provisions of new statute which touch a right in provisions of new statute which touch a right in existence at the date it is enforced are not to be applied retrospectively in absence of express provisions or necessary intendment. The Act of 1997 Act has not been given retrospective effect so as to bring it within its coverage date of tenant occurring prior to July 10, 2001. And a different intention does not appear on a reading of the Act of 1997 so as to affect any right or privilege that has been acquired or has accrued in favor of the specified heirs of the deceased tenant under the Act of 1956 Act since repealed. Having regard to Section 8C of the Bengal General Clauses Act 1899, a vested right that accrued in favor of the heir, like Subhra on the death of tenant, that is Sunil, cannot be abrogated. There is a presumption against the curtailment or of washing away a vested right by repealing legislation, and a construction involving such curtailment or washing away of the right accrued ought not to be adopted unless a contrary intention clearly appears in the repealing legislation. It would not have been, and it does not seem to be, the intention of the legislature to fix July 9th, 2006 as the last date till which tenancy of an heir of a deceased tenant would continue, assuming all the other conditions were fulfilled, no matter when he died prior to July 10th, 2001. The absurd result that the aforesaid extract of Section 2G of the Act of 1997 has the potential of producing is best illustrated by the fact of the present case and needs no further elaboration. Insofar as the situation 2 and 3 are concerned, it is obvious that the definition of tenant in section 2G of the Act of 1997 shall apply, and for achieving the purpose that it seeks to achieve, it was not necessary to insert the phrase "or from the date of coming into force of this Act," or whichever is later. The period of 5 years mentioned in section 2G automatically would have application only in respect of death of tenant occurring on or from July 10th, 2001. And in such case, the portion extracted above is, in my considered view, a piece of loose drafting and ought to be considered redundant unless in a given case, which I have been unable to perceive, the same is shown to have application. I hasten to record here that the above observation regarding redundancy has been made by me despite my best effort to make the statute effective with all the words that have been used by the legislature, and conscious of the principle that legislature is presumed not to waste words. Relying upon the above judgment of Calcutta High Court, the counsel of the appellants would submit that similarly the tenancy in the present case had in fact devolved in favor of the present appellants way back in the year 1970 on the death of their father, who was the original tenant. This would not be undone by applying the provisions of 1997 Act, which was a subsequent legislation. In other words, in 1970, the tenancy was heritable, and thus the appellants, along with their mother, had become the tenant on the property and premises. So here also the mother was given the tenancy, not the sons, and the suit was disagreed. But here the Honorable Court now says, go on to say, kindly see. On the other hand, the learned counsel, Mr. Sabyasachi Chaudhary, appearing on behalf of the respondent landlord, would rely on the findings given by the High Court in the present case, and in addition, he would rely upon two judgments of the Calcutta High Court, Sri Sushil Kumar Jain versus Pilani Properties Limited, 2017 SCC Online, and Satyanarayan Moore versus Miligrina Rose Coronia, which are both division bench judgments laying down a law contrary to the judgment of Gautam De. The division bench of Calcutta High Court in Sushil Kumar had in fact overruled the judgment of the single judge Gautam De. It relied on the statement of objectives and reasons of 1997 Act, and its purpose which was to do away with the heritability of tenancy. The relevant paragraphs have been reproduced below. 20. The underlying logic of the judgment in Gautam De is that if a right vests in a person under a statute, the same cannot be undone. As a proposition of law, it may sound attractive, but it will not hold good in all cases. While it is true that certain rights, if they vest under a predecessor statute, cannot be undone by a successor statute, the purpose of the statutes, the nature of the right, and the extent of the vesting of such rights are relevant consideration. In 1956 Act provides for a degree of protection to the certain classes of tenants in this state. In course of time, the legislative wisdom provided for a relaxation in the norms such that protection was limited to a smaller class of persons, and in certain specified situation by the Act of 1997, it cannot be said, for instance, that merely because a tenancy had been created prior to 1997 Act, the protection enjoyed under 1956 Act would continue even after 1997 Act, which has come into operation. The 1997 Act does not admit of such a situation. It must be also added that the courts ought to be very cautious before finding words used in the statute to be odious by meaningless. The intention of the section 2G of 1997 Act is to regard heirs of the original tenant who were dependent on him and were residing with him at the time of his death as tenants of for a period of 5 years. That would imply that for a period of 5 years from the death of the original tenant, the heirs of the original tenant who were dependent on the original tenant and were residing with him will be entitled to the same protection under Section 6 of the 1997 Act as the original tenant. However, such umbrella protection is removed upon the conclusion of the 5th year from the death of the original tenant, in case the original tenant died after 1997 Act came into effect. For the similar years of the original tenant who had died prior to 1997 Act came into force, a period of 5 years was counted from the date of the 1997 Act coming into operation. It was a policy decision taken by the legislature to afford a 5-year period for the dependents of the original tenant who ordinarily resided with him at the time of death to make alternative arrangements to ensure that all such heirs of the original tenant had the same time period to make alternative arrangements. The clause, whichever is later, was introduced in Section 2G of the 1997 Act, so that heirs of the original tenant who had died prior to 1997 Act coming into force did not have a shorter time to make such alternative arrangements. That is the meaning and purpose of the expression whichever is later in Section 2G of the Act. Thus, the counsel of the respondent landlord would argue that even if the appellants claim tenancy under 1956 Act, then also their tenancy would expire on 9/7/2006. That is 5 years later after 1997 Act came into force. This logic is based on the interpretation of the term whichever is later. In other words, the protection is only for 5 years, even for one who had inherited tenancy when the old act was in force. As it said, 5 years from the date of the death of the tenant, or 5 years from the enforcement of the act, whichever is later. Since the new act came into force in 2001, therefore, although the tenant, and in this case it would be the father of the appellant, the original tenant died in the year 1970, but 5 years will be counted from 2001. In other words, the language of the statute suggests that its purpose was to cover even the date of the death of the tenant which occurred during the subsistence of the old act. But such an interpretation would depend upon whether the new act was a retrospective application. Whether 1997 Act would cover such tenants who were protected under 1956 Act is in question. The High Court has held that the legislature, by virtue of 2G of the 1997 Act, intended to extinguish the tenancy of all such legal heirs who inherited it on the death of their predecessor in interest before the enforcement of 1997 Act. Such right would expire after 5 years from the commencement of the Act. To understand the intention of the legislature, we will have to examine the provision of the 1956 Act and also 1997 Act. The West Bengal Premises Tenancy Act 1997 perceived assent from the President of the India on 28/11/1998, and as per notification dated 9/7/2001, the provision of 1997 Act came into force on 10.
Mr. Mukherjee, we have just read the judgment. The issue there was whether these 5 years period will apply to legal heirs of tenants who died prior to this new act coming into effect. That was the only issue. Yes, anything else?
Here, my lord, what is the main issue, my lord, here was that in 1998, the original tenant died, my lord. And 1956 Act was in force. So naturally, his son and the widow both have inherited the tenancy, my lord. Not the widow only, as in this case. Here the case is, my lord, only the widow was made the party in the suit, and the suit was decreed, leaving aside the sons. The sons challenged the degree, and that was set aside. That is the ratio of the judgment, my lord. This Rajesh Mitra is the son of the original tenant. He was not a party to the original suit.
Upon the death of Satyaranjan Kundu, who became the tenant under the old act?
His wife.
Why do you say also his son? Why are you saying his son?
His son was also residing with him. So naturally, his son is also inheriting the tenancy. His son died in the year 2018. So 5 years protection will go to 2022. The suit was filed in the year 2021. It was the premature suit. And his wife and his two sons, they are also there.
22 other the trespasser. Subsequent fact.
No, Mr. Chaudhary, if Chattoranjan Kundu died in 1998, when the 56 Act was in operation, and if the son was also ordinarily residing with Chattoranjan, of course, this was not a residential tenancy, but doesn't matter. Then why would not also the tenancy devolve?
No, my lord, what entire argument is proceeding on merits. Now, assume for a moment what my learned friend is saying. Even from my learned friend's own submission, whichever way you look at it, ratio of this or not, my lord, whichever way you look at it, 2022 or 2023.
When did Probit die?
Lord, Chattoranjan died in 98, Durga died in 2015, Probit died on February 2018. So whichever way you look at it,
by 2013,
by 2023, everybody has become a trespasser. Now assume the best possible point my learned friend may have. The 21 suit, he is arguing that it does not disclose a cause of action because in 2021, Probir was not a trespasser, but a tenant.
Not Probir.
Yes, Probir. Probir is the son, Chattoranjan.
In 2021, Probir was no more there.
I'm sorry, yes.
Probir's wife.
I'll defend it. I stand correct. Correct. So, my lord, whichever way, my lord, now it is well settled. My lord, if subsequent facts are taken into account, my lord, today.
Yes, but your plaint has not been rejected.
But it has not been, my lord. Whatever, all this has to be decided. Which court will decide whether I get the decree or I do not get the decree. I have not been, my lord, non-suited on merits. I have been non-suited at the threshold. And whatever point my learned friend is saying, that has gone against him in the sense that, Lord, the learned first court has held that they are not a tenant.
That is why he is arguing, because if this finding he allows to stand, it will stare at his face. So we are allowing them to argue this point.
But my lord, if his argument stands on admission, I get a decree in the appellate court because in 23, my lord, order 12, rule 6, my lord, any stage, I get a decree here and now. I doesn't require an application because even on the basis of my learned friend's submission, they are a trespasser in 23. So kindly give a decree.
Consider, even assuming that after the death of Chattoranjan Kundu, this is what Mr. Chaudhary is saying. Upon the death of Chattoranjan Kundu, Durga and Probir became joint tenants. They being legal heirs of Chattoranjan. Very well. In 2015, Durga died. Probir continued to be a tenant. In 2018, Probir died. At the highest, 5 years protection will be available to this defendant. And therefore, in 2023, the defendant would become a trespasser. Consider that also. We have read this, Mr. Mukherjee, the Supreme Court we have read. It is really on a different point. But you have to answer his point.
As far as commercial court is concerned.
That is one point. You are now on 2G, na?
Yes.
You said you have to get over that.
But not in this suit, Lord.
Which suit?
They have filed this suit on the basis that in the year 2015, the cause of action has arisen. The suit was filed in the year 2021.
Yes. Yes.
But in 2021, the 5 years period never did not lapse.
Right, but today?
But today, then they have to take fresh steps.
Subsequent facts can be taken up.
What else do we have to cite?
Now, my lord, as far as the commercial court's point is concerned, my lord, if your lordship looks at the Commercial Courts Act for once, Section 3, my lord.
Yes.
Commercial courts, commercial appellate courts, and commercial division and commercial appellate division. The constitution of commercial courts. The state government may, after consultation with the concerned high courts, by notification constitute such number of commercial courts at district level as it may deem necessary for the purpose of exercising jurisdiction and powers conferred on these courts under this act, provided that with the respect of high courts having original civil jurisdiction, the state government, after consultation with the concerned high courts, by notification constitute commercial courts at the district judge level, provided further that with respect to territories over which the high courts have original civil jurisdiction, state government may by notification specify with pecuniary value which shall not be less than 3 lakhs and not more than pecuniary jurisdiction exercisable by the district courts that it may consider necessary. Notwithstanding anything contained in this act, the state government may, after consultation with the concerned high court by notification, specify such pecuniary value which shall not be less than 3 lakhs or higher value for the whole part of the state as it may consider. So, my lord, it is for the purpose of the jurisdiction, pecuniary jurisdiction, as well as completely as complete provision has been made in the separate provision has been made in the act, which has an overriding effect, not on all other statutes. Whatever is there, Lord, in the normal suits which are pending and which are to be filed before the courts and which are to be covered by this act, having jurisdiction.
Which suits are covered by this act?
Section 2 specifies.
Correct. 3 is irrelevant today. 3 today is irrelevant. Come to 2.
And here 2 says, Lord, as far as our case is concerned, Lord, Section 1, Section 2(1)(c), Clause 7. Agreements relating to immovable properties used exclusively in trade or commerce. So it is used for trade and commerce, that is undisputed. From the plaint, it is clear that it is used for trade and commerce. If that be so, it will have an overriding effect on any other statute which is there, Lord. And accordingly, Lord, the West Bengal Premises Tenancy Act, which is there, Lord, having an effect, Lord, that whether it is a contractual or having an agreement or is covered by the statute of 1997 Act, this act will have an overriding effect on that act.
Where is that non-obstante clause?
There is a non-obstante clause in section 21, if Lordship is looking at that, but that is not perhaps, it doesn't change the scenario.
No. Any other case law, Mr. Mukherjee?
Yes, Lord. As far as non-obstructive clause, Lord, give me another 5 minutes, not tomorrow, Lord,
No, no, no. I withdraw that question. Not necessary.
so that I can. And Lord, this judgment also your Lordship considered the judgment of Justice Dipankar Das.
Gautam De.
Gautam.
Gautam De has been quoted in this Supreme Court. And Gautam De has been approved in this Supreme Court, Rajesh Mitro.
And the learned single judge also considered Nasima Naki. And that I'm also handing over, Lord, if your Lordship considers that. But at the same time, there are holding against me.
Nasima, give us Nasima.
If your Lordship kindly considers in comparison to the judgment that has been delivered here.
Very well. Give us Nasima, both Division Bench and Supreme Court. Do you have both?
Both.
Give us both.
Nasima Naki. এটা একটা কপি দিন।
Mr. Dotto, very short note, very short, bullet form. You take your time, tell us how many days, 2 days, 3 days, next Monday, whatever you.
That's right.
If you want.
Monday.
Yes, yes. That's why you draft it, your senior will settle it, then give it to us on Monday. Mr. Mukherjee, very short, very, very short written note. Just the propositions of law, because
Lord, another judgment of the learned single judge, Justice Sabyasachi Bhattacharya, Lord, regarding commercial Deepak polymer, if your Lordship also kindly considers.
what does his lordship hold?
Regarding commercial matters, Lord, matter will come under the.
The Deepak polymer is presently now before the larger bench. This is Deepak polymer. Justice Bhattacharya's view was that in a determination of lease under section 106, since it is a statutory determination, it is not arising out of a contract. So commercial court will not have jurisdiction. It's the reverse. It doesn't. In fact, my lord, if Lordship goes by that, it is more in the line I have argued that statutory right, my lord, it is in those lines.
Are there conflicting views on that?
No. I don't know what purpose, my lord. I just said what Deepak polymer is on about.
Before the larger bench also.
You want
Yes,
to
but-
rely on that, give it to us. No problem.
But it doesn't help what my learned friend is, whatever propositions he is arguing, it doesn't help. But if he wants to, my lord, it's all right.
So, file your written note on Monday. But kindly make it short.
Very short.
Today we were horrified to see in a matter, a written note was filed before the arbitrator, which was more than 100 pages. My God. Poor arbitrator.
My lord, now, no, my lord, not necessary. My lord, it depends on the personnel of the arbitrator as well. My lord, Lordship will also come across judgments. My lord, now it is reported also. That copying from written notes. Awards have been set aside for copying from written notes and all that. So, written notes it has generated more controversy than
Learned senior counsel representing the appellants, appellant as well as learned counsel representing the respondent. Both are senior counsel. So there is senior counsel representing the appellant and the respondent. Conclude their arguments. Stop. Paragraph. List this matter once again on June 16, 2025, under the heading to be mentioned within court, only to enable learned advocates for the parties to file short capital A, block A, underline করে short কথাটা, written notes of arguments. Short করুন না। কি না নোট নেই, তুমি পাঠিয়ে দাও। Thank you.